Justices of the Appellate Division for Department. Hear you, hear you, hear you. All persons on business before the court will draw near and their attendance, and it shall be heard.
Thank you. Please be seated. First case for oral argument this morning is People v. Sanders, case 298. People v. Vaughn Sanders. Morning, Counsel.
Good morning. May it please the court, I'm Casey Duffy on behalf of Vaughn Sanders. This case presents two distinct violations of CPL 245's automatic disclosure obligations by the Onondaga County District Attorney's Office. First, for more than a year after defense counsel's initial demand, the DA failed to produce any police disciplinary records at all until they belatedly produced just 8 pages of documents 2 weeks before Mr. Sanders' trial. Second, they unilaterally withheld the remainder of disciplinary records that existed in quantities that the trial court described as voluminous. And what's more, they did so using the exact same internal screening process that this court has held was contrary to statute in Rojas-Aponte and People v. Sumler. But unlike those cases, the record as it exists before the court today demonstrates that the Onondaga County District Attorney outright denied that the disciplinary records, even those that tended to impeach the credibility of its witnesses, were subject to automatic discovery under CPL 245. There is therefore no need to remit this case for further proceedings below, when the record before the court today amply demonstrates that the DA's office lacked good faith and due diligence in complying with their obligations under.
What do you make of People v. Johnson? Is that inconsistent with the cases you're relying on here with respect to police disciplinary records?
I think it is somewhat difficult to distinguish Rojas-Aponte, Sumler, and Johnson. Rojas-Aponte and Sumler sort of start with the presumption that at least disciplinary records are subject to discovery, while Johnson is less strong on that point.
But it does appear we may have a slight conflict there in our own case law, fair to say?
I believe so, or at least it's different. It's difficult to sort of suss out what the guiding principle is as it relates to this issue.
But for Rojas-Aponte and our other cases that you rely on to be correct, the proposition has to be true that the people have to turn over all police disciplinary records, even unfounded claims. Right?
By the language of the statute, which says that these materials must be produced regardless of whether prosecution credits them.
And even if they relate to another defendant 5, 10, 20 years ago. If there's a complaint about a police officer in your case, but it accrued years and years ago, it is relevant to the subject matter of the case. And everything, basically everything, founded, unfounded, substantiated, unsubstantiated, everything goes over. Right?
By the language of the statute, I would agree with that. And I think if it relates to the credibility of one of the prosecution's witnesses, that it inherently relates to the subject matter of the case. If it's in their possession, regardless of how old it is, then it's subject to discovery.
I think that issue is pending before the Court of Appeals in a case called Fuentes.
That's correct. This time
that will probably provide the answer here.
It
Or
may
be some guidance, perhaps.
It may. I think that relates to whether or not internal investigative documents are subject to discovery, but it's unclear whether or not that'll determine the outcome in this case.
You want to move on to your second point regarding the detective's identification opinion testimony?
The trial court also erred in failing to preclude Detective Hebert's identification testimony that Mr. Sanders was the individual depicted in this convenience store security camera footage. As the court is aware, in People v. Mosley, there are 2 qualifications that a witness must possess before offering this sort of testimony. One, that he is adequately familiar with the subject in question before the incident that gives rise to the need for his testimony. And second, there has to be some special characteristic that requires this witness's particularized knowledge. And here, Detective Hebert had neither of those things. He had never interacted with or met Mr. Sanders prior to the incident in question. And 2, I think the photos at issue in this case speak for themselves. I mean, there were no special circumstances or characteristics of Mr. Sanders that required a law enforcement official to testify that, in his opinion, it was in fact Mr. Sanders in the.
This is a little different than Mosley, is it not? In that in Mosley, the investigator, the police officer looked at the defendant in the courtroom and said, that's the person who's in the video, in my opinion. The person sitting here in court is the person shown in the surveillance video. Here, it's a little different in that this police detective isn't identifying the defendant that way. He's comparing the photograph taken at the police station, the staged photograph with the mask. There's photograph of the masked defendant after his arrest, after his right to counsel had attached, and photographs of what's alleged to be the defendant in surveillance videos. And he's saying, in my opinion, these two people are the same, right? So it's slightly different. But aside from that, is this preserved? It doesn't look like there was any Mosley-based objection below at trial.
Defense counsel immediately objected as soon as Detective Hebert was about to offer his opinion testimony.
He objected on the ground that a limiting instruction should be given, and it was immediately given. And then there was no further objection. So his objection, again, wasn't to that the investigator shouldn't have been able to testify. It's that please tell the jury that it's ultimately their decision. That request was granted. So I think the people would argue your client's lawyer got everything he asked for. Made an objection, wanted a limiting instruction, got it. And this issue, to be fair, Mosley, I don't think was even decided by the Court of Appeals until after the trial.
That is correct.
I get that.
Yeah. But I think in this instance, the purpose of the objection, whether or not it had been addressed earlier, I don't recall, but to prevent Officer Hebert from offering that testimony, given how prejudicial it would be, especially considering the inferences stacked upon each other to get to the point where you could assume that it is Mr. Sanders in that photo, would be unduly prejudicial. It's
Can I just clarify one other issue if I could?
sure.
A suppression issue with respect to the stage photograph. There was a motion below to suppress the photograph on right to counsel grounds. The defendant's in custody, his lawyer appears, and the lawyer then leaves the police station. The investigator then has the defendant don a mask identical to the one shown in the surveillance video. Takes a picture of it, and that's used at trial. There was a motion to suppress that on right to counsel grounds. It was denied. On appeal, you're not raising that issue. You're not challenging the suppression ruling, as I see your brief.
Well, the identification procedure that resulted in that photo being taken, that is, we do raise that in the brief under point 2. It's sort of nested within it. But
you're saying that the photo should be suppressed. I get that you're saying that the officer's testimony shouldn't have been allowed. I don't see where you're arguing that the photo shouldn't be allowed into evidence. Because if we agree with you on your contention on the defective testimony, the photograph's still before the jury. And your motion below, your client's motion was that shouldn't be get before the jury. It seems like that has been abandoned, unless I'm missing it.
I think at least it was intended to be addressed as far as like the procedure by which this photo was taken was improper, and therefore the photo should have been suppressed.
Okay.
And then the second part of that argument relates to Detective Hebert's identification testimony. And the nature of the prejudice that I just discussed sort of speaks to the lack of the thinness overall of the prosecution's evidence tying Mr. Sanders to the crime. Both of the eyewitnesses the prosecution called, neither were able to identify Mr. Sanders either in court or before court. The DNA evidence, none of it was on objects that directly related to the crime itself. Their presence on these objects is explained by Mr. Sanders' relationship with the mothers of one of the co-defendants. And with that in mind, I would just say that I think—
Wasn't there DNA on the mask too?
Correct. There was a mask, a cell phone case, and a bottle.
And a bottle.
Right. That's correct. And if there are no further questions, I'll leave it there.
Thank you, counsel.
Thank you.
Elizabeth Dannon, for the people. I recognize that the issue of police disciplinary records appears to be before the Court of Appeals. So what I say has probably little weight here, but
We say probably.
yes, indeed. But we would say that we would represent that CPL 24521 KV does not make place any difference between police disciplinary records and impeachment material with respect to any other witness. They should be treated the same. We certainly do not provide wholesale files for every witness to the extent that police disciplinary files are being stated that they should be turned over here. Additionally,
We do have cases from this department, Rojas and Ponte, similar, that say that they all have to be turned over. We may be wrong on that, but we do have case law on that, right?
I don't believe that that was specifically held on. I believe it was, whatever's relevant to the case and impeachment material. I believe that's the language of the statute, and I didn't hear
I
anything.
thought what we were saying there was the party who determines whether these police disciplinary records are relevant is the defense. The prosecutor can't sift through and decide relevancy themselves. I thought that was a tenet, but regardless, the point this case is coming. Do you know if there's a date for argument to Court of Appeals?
I do not, no. I guess we would concede that the court improperly found that the use of a screening committee was proper in light of your decisions in Rojas, Ponte, and Sumler. But here we submit that the record demonstrates the prosecutor complied with his obligation to personally obtain, review, and disclose the relevant police disciplinary records. First, the record makes clear that the prosecutor did obtain all the records, and that's undisputed for all the officers involved in the case. Second, the record demonstrates the prosecutor personally reviewed all the disciplinary records. He uniformly used the first person plural when addressing his performance of the discovery obligations with respect to police disciplinary records. He always used we, not they. Thus, while perhaps other assistant district attorneys, as well as the prosecutor, may have reviewed the disciplinary records, there was no failure on the prosecutor's part to personally employ due diligence, exercise good faith, and his own judgment. And indeed, we would represent that the fact that the prosecutor reviewed the records in conjunction with other members of the DA's office provides additional evidence that the prosecutor was concerned to and did comply with his discovery obligations. The parameters of the obligation to turn over disciplinary records was new at the time of this case. The scope of the disclosure was unclear, and in such cases, it is common for ADAs to consult with each other for advice, or even to turn to a committee that has expressly undertaken a specific study of the matter to ensure that there is a clear understanding and a common policy and application to all cases. But I believe it is clear that he exercised his own personal judgment and did review those. And third, the record demonstrates that the prosecutor did turn over records as required by CPL 245-21K4. As defendant concedes the entire, well, I guess he did not, but the record shows that the prosecutor turned over files to the defense at different times. While the defendant complains that some were belatedly turned over, those records pertain to officers who did not testify and don't implicate the validity of the COC because obviously they didn't testify.
Do you want to shift to the Mosley issue?
Yes, Your Honor, we would submit that that was not identification testimony. I did try to address that in point 2 of my own brief there, stating, comparing Mosley and the statutory provisions for identification, that, you have to identify from a video of the crime from a previous familiarity, and then you can testify that is the defendant. The police officer in this case did not do so. It was not identification testimony.
Right. I agree. There was no notice under CPL where it's required because he didn't identify somebody in the crime. But what opposing counsel is arguing here today and in his brief is that was it proper for him to give his opinion? He's comparing photographs of the defendant, allegedly the defendant. The one that's the staged photograph we know is the defendant. In court, he's comparing that to the surveillance, both with masks on, the same colored masks. His argument is that how is the detective any more qualified than the jurors to compare those people? Our detective had never met the defendant before. So he had less familiarity with the defendant than did the investigator in Mosley. So his point is that should be the exclusive province of the jury. They're equally as qualified to look at the two photographs and make a comparison as was Detective Herbert.
Yes, Your Honor. And the court did twice employ the limiting instruction that the jury was to rely on its own judgment and that it was not evidence. So I
Was it preserved?
The issue is the objection to the identification, the objection that he that the defense requests as far as identification, I do not believe that is preserved because as Your Honor stated, it was an objection requesting the limiting instruction, and that was promptly given. So I believe that the only objection that was preserved was an objection that the limiting instruction be given.
If we were to reach in the interest of justice or determine that it's preserved, what do you say on the merits? Can a police officer do that? Is he any more qualified to compare photographs than those 12 members of the jury?
Your Honor, throughout that testimony, he said it is alleged to be, it is believed to be. He did
Well,
not say it is.
He said, we believe,
Yes, he
like
did.
5 or 6 times. We believe this to be the defendant. Now, that probably is not going to come as a huge shock to the juror because
Otherwise, it wouldn't be.
of course, the authorities
yeah.
believe it's him. They arrested him. But so I'm not sure how prejudicial it was, but he did say we believe. So he gave his opinion that we think these people are the same.
Yes, Your Honor, and
Didn't he identify him specifically though as I at one point on page 745?
back.
745, this is who I believe to be Vaughn Saunders, excuse me, of the vehicle, the red Kia.
Yes, he did offer that opinion, Your Honor, but
So it wasn't always we.
it
think
was,
this.
yeah,
It's
not
an
always.
I. And wasn't Officer Herbert, wasn't he one of the ones who was involved in this stage photograph?
I am not sure.
No, I can't,
He was or
I'm
not.
trying to visualize again if that's what, if he was involved in that, you know.
Okay.
Would that make it somewhat more in the interest of justice as what Justice Lindley was arguing? He's the one who was involved in this stage photograph. He's the one who's comparing it for the jury. He's the one who
Yeah,
identified.
I would have to look back. I do not specifically recall that he was involved in taking
yeah.
that photograph, but it was, I would just say that it was in the middle of COVID when everyone was wearing identical masks all the time.
Do you dispute the fact that there's a right to counsel violation there with the photograph? The lawyer, not only did he request a lawyer, his lawyer was there and talked to the defendant. He leaves the police station and they do a photograph, not just a booking photograph. They say, hey, wear this mask and let's get this for you. Let's get this photograph of you that then's used against them. Is that a right to counsel violation there?
It was not an incriminatory statement. It was just a photograph, Your Honor, and
Right,
it,
but can't you have lineups and other photographic evidence suppressed on right to counsel grounds?
if it's an identification, and this was not an identification, Your Honor.
No,
this
but,
was-
okay. So after the lawyer appears, would it be permissible here or in any case for the police to have the defendant here, wear all these clothes? These clothes match the clothes of the suspect. Let's get you in all these clothes and the hat and glasses, and let's get you looking exactly like the person, the suspect is going to get a photograph of you. After the right to counsel is attached, that'd be okay?
I would say that would probably not be okay, but Your Honor, like I said before, this is the middle of COVID. Everyone is wearing identical
How's
masks.
that dissimilar here then? I mean, they're requiring Mr. Saunders to, after his attorney leaves, now, hey, do me a favor, put this mask on. We need to take a picture of you. How's it different than putting those red shirt on or beige pants, you know?
I guess I
Being
would,
staged. I mean, it's almost like a modeling. You're doing this.
well, Your Honor, I did not, I mean, I know that there was a case Higgins that
Higgins is what from the third department with the lower court.
Yeah.
That it wasn't communicative.
it was not,
therefore it
yeah,
wasn't-
not a communicative statement.
But here, can we just address the COVID issue that you raised?
Yes,
They had masks there. He came in with a yellow mask. They had a lot of yellow police masks there. They asked him to wear a different color mask that coincidentally was the exact same color and style and size as the mask worn by the suspect. So you can't honestly say the reason they put him in that mask was because of COVID precautions when they had all these other masks there.
oh, well.
Then why take a photograph of them?
Okay. Well, Your Honor, I do recall from reading the record, I did not specifically go through with respect to this particular issue, but that they were required to wear a mask to go over to the Justice Center.
Right, not a mask that matched the one worn by the suspect when they have all these other matches. But we understand your point. You want to address any of the other issues?
I believe I will just rest on my papers. Thank you, Your Honor.
Case number 300 is People versus Frederick Broughton. Morning.
Morning, may it please the court, Tanya Plank for Frederick Broughton. I submitted an additional case citation last week that was People v. Clark that came down from this court on March 14th. And I think that that case is very instructive here. Here in their response to defendant's 3030 motion, the people made no arguments whatsoever addressing any excludable time that defendant cited in his motion as the people were required to do. The people instead just gave a brief history, said that the public defender's office already had the case from the time it was a misdemeanor until it went through to being indicted. And they didn't cite any time
Do
specifications
they,
that would be
do people have a
excludable.
statement of readiness and a COC? Do they have to, is the burden on them on a 3030 motion, if they have a statement of readiness and COC, to then go through all the time periods and say which ones are excludable or not?
Well, they
Does the
didn't
clock
have, they
stop
didn't,
running on a announcement of readiness if it's valid?
well, I would argue they didn't have the statement of readiness until May 5th, which was after.
Right, that's the issue in this case, right? Is we had a
Yes,
statement
that's
of
one of the
readiness.
issues, I think.
We had a COC and statement of readiness in city court on November 3rd,
Yes.
2021.
Right,
And you argue in your reply brief that that's not a valid statement of readiness because it was on the misdemeanor,
right, exactly.
that you need a new one if there's an indictment.
Right,
Do you have any
exactly.
authority for that?
Well, I believe that that would be, I mean, it's contrary to the whole statute, the 3030 statute, because otherwise, if they could just, I mean, if the people could just announce readiness on a misdemeanor, then they could have 9 months on the.
You don't
felony.
disagree that that
So,
statement of readiness on the misdemeanor was valid, right? And the COC was.
I mean,
not a-
presumably, there was no argument on that.
There's
So
no challenge.
presumably,
There's no challenge to the COC in city court.
in city court, no.
Your motion, you ignored the COC and statement of readiness in the motion because on the view that, yeah, we're on a felony now and that
Right.
doesn't apply.
Exactly. It's a nullity.
But again, I'm curious of whether that's true legally. I've seen some cases going both ways on if you have a misdemeanor. Here we had assault third.
Yes,
If people announce readiness in local court and it's valid,
right,
the people say, wow, these injuries are worse than we thought,
right.
as here. They go to the grand jury, get an assault second indictment. Do they have to state readiness and file a new COC? You say yes, but
Yes.
is there a case
Well,
that you have on that?
There are lots of cases that I cited in my brief. I think Cole, Berkowitz, Benson, rather. There are several cases that state that the people cannot be ready on an indictment until an indictment is filed.
Okay,
There needs to be an indictment. There needs to be a grand jury to have an indictment. So I don't see how there could possibly be how a statement of readiness on a misdemeanor could possibly pertain to an indictment.
okay.
And so
And if that's true, then there's no statement of readiness at all on the felony.
right,
Surprisingly, after the new indictment came down, people
Right.
didn't file a COC or state
Exactly.
readiness.
exactly.
And then it's an easier case for you. But what would you say, is that issue preserved? For our
Well,
review, did you say, hey, the statement of readiness in city court doesn't apply here on the felony?
I mean, I would argue that the defense counsel she didn't state that because there was no argument here on the 3030 motion. The court, when the court handed down her ruling, that was later. And then the defense counsel did take an exception, but there was no argument at that point. And I think that defense counsel properly treated it as a nullity and didn't address the
Right,
state.
but
the
your
certificate.
point is, why would I have to, if something's a nullity and
Right.
everyone knows it's a nullity and I know it's a nullity, why do I have to, I'll just treat it like a nullity. I
Right.
don't,
Exactly.
you do argue this issue in your reply brief,
Yes,
and that's where you cite these cases.
right. That
Uh-huh.
state that otherwise, I mean, the people could have kind of at 9 months on a felony to be ready. If they added the misdemeanor and the felony together, they have to state readiness on the indictment after the indictment.
So this idea that, because your motion was primarily based on the fact that on the felony, we keep getting new discovery from the people.
Yes,
The implication is that the COC wasn't with due diligence because we keep getting things, right? That's the motion.
right.
But doesn't the whole statute contemplate continuing discovery obligations? You're going to get discovery after the COC, right? I mean, it's not,
Right.
it doesn't
there
mean
can be
that
discovery after
the initial statement of readiness and COC was illusory, just because there's new evidence that comes up and gets turned over.
No, it wouldn't be illusory, but in this case, there just was no, I think that the defense counsel probably treated this as a nullity since there was no statement of readiness prior to the indictment. She just didn't address it because there was no statement of readiness. So she treated it as there not being a statement of readiness.
Yeah, well, if that's the case, I don't get why it's relevant that the defense kept getting new discovery items. That would seem to be relevant if you have a valid COC, and your argument seemed to be it wasn't so valid because we keep getting things.
Well, I think she was arguing that they haven't met their they haven't met their 30/30 time. It's now, she argued that it was now 242 days. By the time she made her motion, it was now 242 days. And the people were still submitting discovery. And so they obviously hadn't, I guess she's saying that they obviously hadn't filed a COC or statement of readiness by that point as they needed to, and they weren't ready, in fact, because they were still providing discovery. So, and then, I mean, I still believe though that the court sua sponte should not have decided any of this because defense counsel didn't make any of those, the people did not make any of those exclusions, state any of those exclusions in their responding papers as they were required to. If there are no, I mean, I have arguments on the other two findings of fact sua sponte by the court, but if there are no further questions on this issue, I guess I'll rest on my main brief and the reply brief.
Hearing none, thank you.
Thanks.
May I please the court, Virginia Harper for the people. The people here in this case announced their readiness within the statutory period of time. Here,
So let me ask you a question. If the people are asking for an adjournment to present to the grand jury after you file the COC and never announced ready, according to the record, is that correct? They never announced ready. So how could they be ready if they've asked the court to, essentially they're taking away jurisdiction of the court to present to the grand jury?
so what happened was this case was pending as a valid misdemeanor information in lower court. It was scheduled for trial on at least 2 or 3 different occasions. And it wasn't until January 26th when the people requested an adjournment to present to the grand jury.
Right, and doesn't that divest the court of jurisdiction at that time?
It does once the indictment is filed.
Even when they're requesting they're alleging their time that they need to present to the grand jury. So at that time, the court is divested of jurisdiction.
My understanding of the statute is that when the indictment is filed.
Okay.
So technically, when the request is made, we still have a valid accusatory instrument. It's not until the grand jury action. It's not until such time that the indictment is filed that the court is divested of jurisdiction. So here,
You argue that the announcement of readiness in city court on November 3rd and the COC filed in city court on November 3rd carry over to the felony post-indictment, that the people don't have to re-announce or refile, right?
So, Your Honor, the case, while it was pending in the lower court, there was a valid announcement.
Nobody disputes that one. Okay.
And that carries over because in deciding a 30-30 issues, the court has to look at the very beginning when the case started. And that in this particular case, the case started with the filing of a misdemeanor.
Nobody disputes that.
So
what, again, and I'm not saying you're wrong. I don't know the answer. I've been on Westlaw looking, and you state readiness. People have a valid statement of readiness in local court. And this could apply even under the old discovery laws, right?
yes.
The people want to upgrade the charge. They do upgrade the charge, get an indictment.
Yes.
Does the statement of readiness in city court mean they're ready on the felony indictment?
No, it doesn't, because they don't have the indictment yet. But at the time when the case was pending in lower court, they were ready to proceed
I
with the
agree.
misdemeanor
I'm
charge.
not arguing that one. So sounds like you just conceded. Once the felony indictment's filed, maybe sooner, as Justice Greenwood indicated. But let's take your date. The indictment's filed in January, is it, of 2022?
Yes,
Then they have to announce readiness again. The people do, right? To stop the clock.
they would
And-
have to announce readiness on the new accusatory instrument.
And they never did that post indictment.
They did.
When?
They announced readiness after the motions were filed. That was on May 5th.
Right. Okay. Well, all that time up until then is charged to the people, right?
Not all of the time, Your
How's
Honor.
that?
So I would argue that we still have to look at the exclusions. So there's excludable time that should not be chargeable to
Right.
the people.
Okay.
So when the case was pending as a misdemeanor information, a valid misdemeanor information, people were ready to try this case. They were ready for trial on that particular accusatory
Right.
instrument. We
I
didn't
agree
have
that-
an indictment.
I
yet.
agree, but we have Judge Barrett found 67 days charged to the people in city court. You don't dispute that?
I don't dispute that.
Okay, so we got 67 already. What's the
Yes.
total number?
184.
184. So you already got 67 against you.
Yes.
Post indictment. There's no statement of readiness, so it's just whatever was requested, whatever adjournments were requested by the by the defendant is excludable, right?
So
Am I right?
post indictment, the case was indicted on January 28th.
Okay.
So even if we look at the time and even if, so pre-indictment, we only have about 81 days.
Okay.
That's up to January 28th.
So you got 83 left.
So even if this were to decide that the entire time post indictment until such time that the people file a supplemental certificate of compliance is chargeable to the people, they're still within their time frame as of May 5th to announce their readiness.
How do you figure that? You get 180, you just acknowledged 81 is charged to the people before it goes to county court, right? 81 against you out of 184.
And
What you just
then,
said.
so
It's
from,
83, and then we go from January 28th to May.
so Yana, the time stops because the defendant filed 3030 and omnibus motion
Okay,
on
what was the
April
date of that?
15th, April 15th of 2022. So the time is excludable because of the motion being considered by the court. So the time from April 15th until May 5th does not.
So basically, we don't want to take everyone's time here today doing math, but we just got to count. It sounds like we agree. You agree with the defendant. The statement of readiness doesn't apply in a felony. The local court statement of readiness, your brief says otherwise, but we'll overlook that. We have no valid statement of readiness. And now we just need to see who requested what adjournments post indictment, right?
Your Honor,
What time is chargeable to the people and what time is excludable?
I just wanted to clarify that there was a valid announcement of readiness on November 3rd,
Right,
and
so
people
Mr.
were ready on a misdemeanor.
But you just said that doesn't carry over to the felony.
Well, I don't believe, Your Honor, in good consciousness, I can say that carries over
Right.
because
I
it's
commend you for
it's a
that.
felony indictment. However, the time is still excludable in Rochester City Court because they were ready on a misdemeanor charge.
Well, wait a minute, 81 days are not excludable. You just acknowledged that.
That I acknowledged.
Okay.
But the time while the case was pending in lower court and it was scheduled on for trial several times, that time is
yeah, all right.
excludable.
I
Because
think we
of-
get your point. We just have to go adjournment by adjournment and decide who gets charged with it. And then we get that tricky issue that the defendants argue all the time. They argued here is that there has to be some causation here. And we never really get to the bottom of that one. We may have to here, but I think we understand where we are now and we get some clarification. So I appreciate your time.
Thank you, Your Honor.
Thank you. Case 303 is People versus Lipton. Morning.
Morning, may it please the court. Ryan Muldoon for Andrea Lifton. I brought up several different issues in this brief. Is there any specific point the court would
Let's
like?
get right to the right to counsel. Your client said she didn't want to talk 6 times during the interrogation, 3 to the first investigator, 3 to the second. The trial court said that was that was conditional, that was unequivocal, or if it was not unequivocal, you want to be heard on that one.
Yes, Your Honor, that's the one I wanted to hear to start with anyways. That's the one where my client was working. The police came and picked her up, brought her to the station at the late evening of August 18th to the 19th of 2020. During that time, she did speak with the officers. They gave her a standard waiver here, and I guess Rochester PD uses, where she stated that when she signed, said at any point if she wanted to stop talking, she could say that she wanted to stop talking. She does say it several times to the investigators that she doesn't want to talk, and they continue to question her. I mean, we're at the late hours of the evening. I think you can see in the video recording. I mean, this goes right against People v. Glover with the mixed question of law. And I mean, I think the facts here support that she invoked her right to counsel, invoked at least her right to stop, maybe not counsel, but to stop her questioning.
Well, the people, and I think the trial court relied on Lowen, People versus Lowen from the third department, that trial court seemed to find here that her statement that I don't want to talk anymore could be reasonably interpreted as I don't want to talk about that particular subject. In other words, she says, I didn't kill my baby. And if you're going to keep saying I killed my baby, then I'm done here. What do you say to that Lowen argument?
Well, I would say that this goes beyond the Lowen argument. This isn't one time where she invoked this. She continuously invoked this. This is in the late hours of the night. We have a mother that has just lost her child within like several months, not even several months. She's at the police in the evening, and they continue to question her, even though she says this. This is not two officers. It's not one officer. We have two officers here. I believe they were also in a secured room at which is quite different than the more friendly room to speak in, where I mean, they had given her Miranda and she had invoked her right to remain silent. I mean, they continuously asked her. I mean, this isn't like one time I don't want to talk and then she started up again. This was from them continuously questioning her.
Anything further on that or other points?
The other point I wanted to talk to about, Your Honor, is the character witness issue in my point 5. I believe the introduction of Miss Marshall as a witness basically was brought in to try to make the jury dislike my client. It was basically
Wasn't she also there though to show that the child was well, not ill, when she took care of her? I mean, because she was a babysitter essentially, right? I mean, there was a relationship between your client and her, but there was
Yes.
also, she kind of cared for the child, correct?
Correct, but I think she went beyond saying about the child being well. She then started to make comments basically about mostly her dislike of Mr. Love, the co-defendant, and not a favorable opinion of my client, saying she became a weekend mother, trying to paint her in a bad light. I mean, the prosecution could have kept it solely to the issue of the asthma or the child being well, but we got into comments about what kind of person my client is. Then additionally, the burden shifting in the closing statements. I believe that the prosecution went outside the bounds. I mean, courts give great latitude for closing statements, but here we are making discussions in regards to regarding her not answering questions that were never asked at trial. I think this has evolved around People v. Spinelli, 214 AD 2nd 135 in the second department, where yes, some of the stuff did come into evidence, but there were no questions asked to my client. My client chose not to take the stand, which was her right. And they were basically saying her silence is showing that she was guilty. And lastly, I'd like to talk about the Domestic Survivors Justice Act. I believe that she falls under satisfying all three prongs. The people make an argument about the second prong. It wasn't a contributing factor to the offense. I would say that in the papers provided by defense in regards to the sentencing request of the SGA, there is discussion that she was abused that day by her co-defendant, where she had to run out of the house. Other than that, I would rest on my papers.
Thank you.
May it please the court, Bridget Field on behalf of the people. I guess I'll start backwards with the last argument about the DVSJA. I don't think that the papers were sufficient. The Judge Argento offered the opportunity for a hearing. The defendant put on no evidence. She submitted a self-serving affidavit. No documentary, no medical evidence, no medical support, no psychiatric evidence, nothing to tie together the fact that any abuse she may have suffered, and I'm not agreeing that she did, but I'm not necessarily arguing that either. But there is
defense counsel on that argued that the day of, I don't know if it's the incident or the day that they took the child to the hospital, that she was apparently abused, but wasn't it days before
I believe, I'm sorry, I didn't mean to overspeed, but I don't believe it was the day of, she had been at work prior to getting home and the child, she called an ambulance. But I do believe it was within days of the incident that Ms. Lipton had called the police. But she turned them down
What
when
about the time that the child was, I think with the grandfather was there, were they at the court at that time? And there was a video of the child.
There is a video of the child, and that was.
That's before this particular incident where she said she was abused.
Correct. This was days before.
Right.
I believe that it was very early in July. The death occurred approximately July 11th. If I'm recalling the record correct, it was July 8th, and there's video from the transit center, and Greg Peck had put together a compilation video, but it's a very telling and horrific video, quite frankly, because it shows Miss Lipton carrying her child at the transit center, then walking up to the magnetometers at the Hall of Justice, in through the mags, up to the third floor, her dealing with something at the counter in the third floor's clerk's office, and then again going back out through the building and back to the transit center.
Does the statute or the case law require the defendant to put on oral testimony? I mean, isn't this type of thing by definition a self-serving statement she's going to put out saying that I was abused? I mean,
certainly that would happen. But the statute requires corroboration, I believe. So there's three parts. First, was the individual abused by someone who meets the definition in the Family Court Act? So either a family member or a intimate partner. But it just having been abused isn't sufficient. There then has to be established the element that the abuse was a contributing factor to.
Have to be a substantial contributing factor, just not a contributing factor.
Correct.
And it appears as though this child was subject to significant abuse over a significant period of time. There's a lot of bruising. I think that was one of the reasons that the defendant here failed to take the child to the hospital earlier.
Yes.
The fact that, okay, well, how am I going to explain all these bruises? How am I going to explain all this?
There was an indication, and I'm not sure where it was in the interview, that she indicated at some point that they did not want CPS involvement. There had been
She lost
testimony.
another kid to CPS, and she said at the end of the first video, that's why she didn't take it. She was afraid she was going to lose the kid.
Correct. She had three at the time of the 3-year-old's death. She had 3 children. One was lost, or one was placed elsewhere. Then there was a 4, 5, 6-year-old, Blessing, was with, at least at the time of trial, was with Miss Marshall, and then the 3-year-old that passed away. So she had involvement with CPS prior, certainly. But I think that if you look at I never get the initials right, DVSJA cases, there's significant case law that talks about the participation of doctors, of other support other than self-serving statements. And I'm not denying that there would be self-serving statements, but in this case, she elected not to take the stand. So they were self-serving statements, not subject to cross-examination. And she certainly could have taken the stand to flesh some of those out. So I think Judge Argento's decision not to apply the DSVJA to sentencing was very appropriate. I do believe that Miss Marshall, going to point 2, was called to establish that the child was healthy as of May. So she testified that she had been caring for the child, with the exception of the weekends that mom would occasionally have the child, but she was a primary caregiver for a significant period of time. And it was important for the jury to know that this was a healthy child, because that stands in stark contrast to that video that was admitted into evidence of the child at the Hall of Justice with its legs dangling, not wanting to stand up. That's not typical for a 3-year-old child. So Miss Marshall's testimony was important in that regard. It also was important with regard to her information about the child's asthma diagnosis. I mean, asthma can be, from somewhat mild to very severe. Miss Marshall's testimony was that this young man did not have severe asthma attacks, and the failure to give him a inhaler, he wouldn't have been in immense distress. And at the time that the paramedics were called, both parents, certainly, or not parents, Mr. Love was saying that he believed that the child had been suffering from an asthma attack. This was also, the treating physicians also disagreed that there would have been an asthma attack at issue. So the primary focus of Ms. Marshall's testimony was certainly relevant, and to the extent that it did surpass that, it was harmless under the circumstances of
Can we,
this case.
Move to issue 1?
Of course.
I get why you wanted to talk about those other issues. I would too if I were you. The ice is a little thinner at this end of the pond.
I agree with, the people agree with Judge Argento's finding that this wasn't, there was some mention about there was no request for counsel at all. So it's just a matter of whether she was invoking her right to silence. And given a review of the entire video, the comments were within, I believe, about a 10-minute period of time during the approximate 3 hours that she was questioned. And she wasn't, she may have been in a secured room, but she wasn't handcuffed.
All right, well, let me ask you this. She says the first time, I have nothing to say. Now, that was conditional, I agree, because she said, so if you're saying I killed my baby, I have nothing to say, so I'm with you there so far. That's
Absolutely.
implication number 1. Okay, you got 5 more to go. Then she says to the same investigator, I have nothing else to say, nothing, because I didn't kill my baby. The investigator keeps going. She has invocation number 3. I have nothing else to say. Go ahead and place me under arrest. At that point, the investigator who's accusing her of wrongdoing, right? We have 2 investigators in the room.
Correct.
That guy gets up and leaves. He hears, I don't want to talk anymore. He gets up and leaves. That's kind of indicative. But then we get the new investigator, the nice guy, good cop, bad cop situation. He comes in, couldn't have been nicer. His focus was a little different. He wasn't blaming her. He was blaming her boyfriend and showed her all the text messages. Look, what a bad guy. He's cheating on you. And look, you're a hardworking woman. You get up at 5:30 in the morning. And I know he shifted the tactic. The first investigator was, you killed your baby. The second one was, he killed the baby. And can you help me with some statements against him? She then says to this guy 3 times, I don't have anything else to say, further to say. I don't have anything else to say. I'm done talking further. So just go ahead and arrest me. So the last three, again, she wasn't being accused of killing her baby. The investigator was accusing the boyfriend of it. So how can we say that she didn't mean that she didn't want to talk anymore on those last three?
I don't have anything else to say. It's not, I want to remain silent. I don't have anything else to say under the circumstances and reviewing the video as a whole is I don't have anything different to say.
I'm done talking, because that was one of them too. That's a little stronger?
It's a little stronger, but I certainly would not concede that this was an invocation of the right to silence. This evaluation needs to be undertaken, looking at the video, reviewing the circumstances, reviewing her actions, as she's saying that she kept talking. You know, she didn't do anything to indicate that she didn't
Right.
want to talk.
I've seen those arguments on right to counsel where they keep talking. Well, then there would never be a right to counsel violation if they keep talking, because they always do, and that's why we get suppression motions. But when she says, I'm done talking to the second investigator, like, what do you think she meant? She was done talking about what?
I don't think she wanted to, I think she wasn't going to change her story. And I think that I've told you, I'm not going to change my story. I won't answer any more questions.
Okay.
I'm not going to change my story, which
Who's
is
got the burden here?
different than
Does
I
the,
don't want to speak at all anymore.
Who's got the burden of proof on a motion to suppress statements as involuntarily made? I think it's the people, and the burden's beyond a reasonable doubt. I could be wrong on that, but
I would agree, but I'm not equivocal on that
Yeah.
statement standing
I
here,
feel
Your
pretty
Honor.
confident that the burden's on the people, and it's beyond a reasonable doubt. So that's, you make some good arguments. I just don't know if they reach that beyond a reasonable doubt, and if in fact that's the standard. But we're gonna take a look at that very carefully, because that's it's an important issue here.
It is an important issue, certainly. I would also argue that there's nothing that she says in this statement. In what she says, she does make some incriminating statements, but this is in a situation where she gives a confession.
So it'd be harmless then, in your view?
I would certainly argue that under the facts of this case, that this would be harmless. She does not make a full admission of guilt at all during this statement. She makes some statements, and I did not review the video last night, so I'm not 100% on where some of the statements were. She did say something about not wanting CPS involved. She was angry about allegations about Mr. Love, but she did not make a
Didn't she make an
confession.
allegation that she acknowledged that if she had gotten medical help for the child sooner, he would not have died?
She did, and I can say I do not recall where in the statement that was made. Again, I didn't review.
She's saying it was a little reckless, maybe.
I don't recall. She never used the word
I know,
reckless.
but
At least in my recollection of the
no, I
video.
don't think she did either.
She
But
never used the word reckless.
no, I don't think she did
Um,
either. But I'm just saying, isn't that I don't have to use the word reckless. I was reckless when I caused this, but looking at this, isn't it? If I had gotten a medical help sooner, that he wouldn't have
I
died.
still think she did not make an admission of guilt
She did say,
during this.
which is kind of incriminating, maybe not a smoking gun, but incriminating nevertheless, that she didn't want to call CPS because she was afraid she was going to lose this child too, if they found out about the bruising. That seems to be the whole theory against her, is that, why didn't you get help for your kid who you love? Well, I can take him to the hospital and I'm going to lose the kid. That's kind of incriminating. That was after the right to counsel. I'm sorry, the right to remain silent, but we're gonna take a good close look at the record on all of that.
Thank you. Your
So
Honor.
thank you very much. Case 305 is matter of Salvatore Y. We have counsel virtually, so if you bear with us a moment. We're waiting for Miss Lorenz. And she is there. All right, counsel, you may proceed.
Thank you, Your Honor. I'm representing Shondell, I'm Charles Greenberg representing Shondell Y. As she's appealing from the revocation of the suspended judgment. I think that when evaluating the brief that I submitted, rather than focus on, the forest, I'm sorry, focus on the individual trees and go down point by point as to what she did do and what she didn't do, I would ask you, for the purposes of argument, is to take a look at the bigger picture and acknowledge, I think, two things that I think stand out. First is that the DSS went in and filed their petition 3 months into a 6-month suspended judgment. So she still had 3 months to go to finish whatever it is that she needed to finish. And then secondly, the second part of the big picture is that in many ways, the underlying order in some ways kind of like set her up to fail. Like they make the production, they make the argument of how she missed visits, but they gave her requirements that were quite onerous to exercise the visitation, specifically that she had to be there 1 hour beforehand. Never before had that been, I'd ever seen that in 30 years of practice. They had to be there 1 hour prior to the visit.
Well, wasn't it because she wasn't making visits before, so they were giving her another chance and said, okay, so you don't have these excuses for missing, we're gonna tell you you've got to do it an hour before. That's how that came about, wasn't it?
I'm not sure that really solves the problem. She was missing the visits, part of the reasons why.
Well, whether it would have resolved the problem, that was their solution, I think. Isn't that what the record shows?
But that was made in the solution, but Your Honor, it wasn't part of the underlying order. So being there 1 hour early is not, or like if she was there the 1 hour, okay, even if we were to say that they had the right to add the 1 hour, but then they were violated. This is, but even when she shows up, let's say she misses the 1 hour, but she's there 45 minutes beforehand or half an hour.
But did she miss 4 visits entirely, like not even being early, but she wasn't even late? She's never showed.
That is correct. But
Yeah, so your argument is you acknowledge she didn't comply with everything of the suspended, it was the 6 months of suspended judgment, which is like a second chance, the last chance to give her an opportunity not to lose her children. You had all these conditions, one of which was visitation. Between, I think it was January and maybe March, she already missed 4.
She missed the 4.
4, and then she got discharged from treatment for being non-compliant. She failed to complete a drug and alcohol evaluation. Like I'm not talking about treatment, I'm just talking about sign up, answer the questions for evaluation. She had all sorts of other violations. I guess you're saying that's just not substantial enough.
Well, I think that part of the problem why she has such difficulty is that she's not really a wealthy woman. I mean, she had trouble with transportation and, mass transit in Buffalo it's not the best. It's not as in New York City where you can just take a subway anywhere. Or most places anyway. She also had trouble taking the phone. So I think that by you're using her poverty against her by failing to,
I think the mass transit in Buffalo is adequate.
well,
Very defensive of mass
it
transit.
depends on where you want to go, I suppose, but.
They have schedules and.
Well, within the city limits of Buffalo, I would say, but if you were going out further, then that would be a problem, but.
So
But-
what about the judges making the finding that her testimony wasn't credible? How should we treat that?
Well, you could always assert yourself and judge the credibility for herself. I mean, it's like, I do concede that this case law is legion on the idea that your court, the trial judge, in this case, family court, a very wide discretion, but it's not unlimited discretion. So you can certainly make your own judgment to evaluate her credibility.
So your client the child has been out of her custody and care since September of 2020.
That's correct. That's
So
what the record.
we're going on 4.5 years. Do you want us to reinstate the suspended judgment?
That would be correct, give her the opportunity to
Give her even more time. And the child's in foster care with foster parents who want to adopt the child. But we're gonna put it on hold again to give her some more opportunities. That's what you're asking.
Well, yes, and I would also just, respectfully dispute the departments. I think at the end of their brief, this is, you want to continue it indefinitely. At some point there does have to be a cutoff. So this would be like truly the last bite of the apple for her. But I think that when you look at the bigger picture, that I think that they prematurely filed their motion and they did use her poverty against her, and they probably gave her conditions above and beyond what the literal words of the order. So that would be, as a matter of equity, they can give her this one last chance.
Thank you very much.
You're welcome.
Counselor Fiducci?
Good morning.
Fiduski,
Sam Fiduski for the Erie County Department of Social Services. The department would just note that if the petitioner is established by a preponderance of the evidence that there's been noncompliance with any of the terms of the suspended judgment, the court may revoke the suspended judgment here. Other than that, unless the judge has any questions for me, we would just rest on our papers here.
Ms. Lawrence, you have the last word.
Good morning. May it please the court, Jennifer Lorenz, attorney for the children. Just very briefly, there's ample evidence in the record to support that the mother violated several terms of her suspended judgment, not only with respect to visitation, but especially with respect to substance abuse treatment and compliance, and that it's in the best interest for the children to terminate the mother's parental rights. And other than that, I will rest on my brief.
Thank you. Next case is 307, matter of Gemma M. 307. Good morning, Counselor. We are waiting for Ms. Cuomo, who has just appeared. So we have everybody and you may proceed. Thank you.
Thank you. May it please the court, Thomas Babylon on behalf of Appellate Ashley M. The first point I'd like to discuss this morning is that the agency failed to prove permanent neglect. It's the agency's burden here by clear and convincing evidence, first to show that they exercised diligent efforts to encourage and strengthen the parental relationship, and then to prove that Ashley failed to plan for the future of the child during that statutory period. First, I'd like this court to take a very close look at the transcript of the lower court's decision regarding diligent efforts, because many of the facts the lower court relied on are not supported by the record, and in fact are directly contradicted by the record. And this is all laid out in detail with regards to my reply brief to the attorney for the child, who stated that decision as evidence of diligent efforts. Additionally, for a period of almost 2 months, there was no actions whatsoever by the agency in this particular case of the 12-month statutory pled period. There was no effort to assist Ashley with housing or to inform her that she didn't qualify for the available housing that the agency had explored. They never referred her to supervised visitation, something which they didn't plead, but which they held her accountable for not completing it. They never referred her for supervised visitation with regard to this child. The agency also here failed to prove that Ashley failed to plan, despite being physically and financially able to do so. In this pled 1 year period, Ashley completed many services, including family therapy, psychological evaluation, substance abuse evaluation. She graduated from a 3-day-a-week program, and she also graduated from drug court. All this, despite the majority of this 1 year pled period, which the agency chose being during the COVID pandemic. And this is what they chose to plead, because it's their option to plead whatever 1 year period they like. Because Ashley's plan must be reasonable and feasible, this court should look to the feasibility and reasonableness of that planning during the COVID pandemic, where it was difficult to find housing. The agency acknowledged this. Employment was difficult to find. Programs were unavailable. This is all acknowledged in the record. And where it was difficult actually in-person visits and home visits were prohibited by the agency during this time. Under these circumstances, the agency failed to prove by clear and convincing evidence that exercised diligent efforts or that Ashley failed to plan. The second point I'd like to discuss this morning is that Ashley was denied due process when the court proceeded to a dispositional hearing before making a decision on the fact finding. Here, the statute specifically requires that a decision be made on the fact finding hearing prior to the court moving forward on the dispositional hearing. And this was not done. The court combined the two hearings into one.
Is that issue preserved?
I'm sorry?
Is that issue preserved?
Well, Judge, I do not believe it was preserved, but this is a serious due process violation. Ashley was entitled to notice of the statute requires her notice of the decision in the fact finding prior to them proceeding in the dispositional hearing. So if the court finds that that was not preserved, I would ask that you consider it in the interest of justice. And the reason these two hearings are specifically isolated by statute is because they have different burdens of proof and they have different evidentiary standards. In fact, the evidence in a dispositional hearing is prohibited from being used in the fact finding. So when the court combined these two hearings into one, it almost makes it impossible for the court to consider this record because it cast doubt on the competency of the evidence and the burden of proof and what the court relied on in determining either one of those things. And the cumulative effect of this is a result in this record where it's difficult, if not impossible, for this court to review, and it violated Ashley's right to due process. And I would argue that this requires reversal. The third point I'd like to discuss is this court erred in determining that freeing the child for adoption was in the best interest of the child. Here, the court determined that it was in the child's best interest to be freed for adoption, yet there was no evidence from which this court could make that determination. Specifically, the foster parent did not testify. There was no evidence regarding the foster parent's intent to adopt. There was no evidence regarding that the foster parent would facilitate sibling visitation. There was no evidence of bonding between the foster parent and the child. There was no evidence of conditions of the foster home or anything else from which this court could make a determination that adoption was in the best interest of this child. Now, the AFC in their brief said, well, you know, the agency wouldn't do this if they weren't willing to adopt. Well, that's not evidence. And I'm sure he's going to come up here and say the same thing again. That's not evidence. That wasn't before the court, and this court should not consider that. They shouldn't consider things that this court didn't have before it. Additionally, none of these deficiencies were addressed by the agency's case notes, because the case notes were specific to the statutory period, which was a time in which this foster parent didn't even have the child. The child was with a different foster parent. I believe there's two notes in the case notes with regards to this foster parent. One is that they're moving her to this new location, and two is the child is there. So there's actually no evidence from which this court could have determined that was in the best interest of the child. Specifically, when the court was aware in this case that Ashley had full-time employment at the time of disposition, she had adequate housing, and that she had completed all of her services. So, and additionally, the court didn't weigh any of the factors in the best interest determination. It basically said, well, adoption's in the best interest because you permanently neglected this child. That is prohibited. The court has to consider the best interest. They can't just say, well, because the child was permanently neglected, it's suitable to adopt the child. The next point I'd like to discuss is that the court erred when it failed to make an inquiry into Ashley's serious complaints about her attorney, and Ashley was denied effective assistance counsel in this particular case. Here, the court had the obligation to investigate her complaints when Ashley told the court that the petition was filed 6 months prior for termination of parental rights, and he hasn't even discussed it with me, that she called and sent emails to him numerous times, and he had not responded, that he refused to speak with her except for a few minutes after the court appearance, and then she felt that she couldn't go to trial with an attorney that wouldn't communicate with her. Now, this happens at the very next court appearance. She showed up to court and was forced to defend against a motion that she had absolutely no knowledge of. Even though her attorney had been served with it 6 weeks prior, he did not communicate with her that a motion was on the calendar for that date. She had no idea. So in addition to that, there was multiple things that the trial attorney failed to do that accumulated in ineffective assistance of counsel for Ashley. He aside from what I just said, he failed to request records that showed that he completed her services, even though he said on the record that he would do so. And the department in an earlier case had said she had completed all her records, but in this case said, or complete all her services, but in this case said she did not complete those services. He failed to call Ashley to testify, even though she had testified earlier that day that she had stable housing, a full-time job, and completed all her services. And he failed to cross-examine the caseworker or either one of the caseworkers on any of these things. He failed to object to. I'm almost finished. I'm sorry. You have a question? I'm sorry.
No, you anticipated what I was about to say.
I'm sorry. Oh, okay.
No, it's you're running a little short on your time, but
I just would say that the cumulative effect of all of this is that she was denied effective assistance counsel. And if there's any other questions, I'll just rely on my brief.
Thank you very much.
Thank you.
Mr. Cuomo?
Good morning. May it please the court, Lisa Cuomo on behalf of the Onondaga County Department of Social Services. I would note that the child had been placed in foster care since her birth on October 2nd of 2019. She had been in care for approximately 3 years when the termination petition was brought. I would also note that it is our position that the department exercise diligent efforts in trying to assist Ashley in obtaining housing. I would note that there were times when Ashley was not in a stable residence and was moving around quite regularly. I would also note that at times she was also back with her husband, Gregory, who was considered by the department to be someone who was a danger to the children. I'd also note,
Ms. Cuomo, more importantly, isn't that in the record as testified to by the caseworker?
yes, Judge.
Right.
Yes, I would also note.
Can I ask you a question? But didn't the child move? Wasn't she worked first with an aunt for the 2 years? She was taken shortly after birth, but wasn't she first with an aunt and then moved to someone else?
It's my understanding that she was with an aunt for the first year and then she moved to another maternal aunt for the second 2 years. And it's my understanding, obviously from the record, that the maternal aunt was willing to adopt that child, the second one. Patricia, the first aunt, was not able to do so. She had already taken the other 2 children.
And did they bring the mother when they had the supervised access with Gemma? Was Gemma brought when when the mother was having her supervised access with the other children? Did they bring Gemma there as well, or did they not bring her?
I believe they did because the supervised parenting time ultimately took place at the grandfather's house.
Okay.
And so they all were able to meet there with supervision. And she did have some intermittent supervision at that time as well. And I would note that obviously there was a kin gap hearing earlier that day when Ashley testified and the judge found her to be not credible. So I think by not calling her as a witness, that probably wasn't a bad idea and was strategic as far as indicating that the attorney may have been ineffective as a result of that. And I'd also note, obviously, the biggest roadblock for Ashley was that she refused to take a court-ordered 5-panel drug test. And as a result of that, it would have indicated to the court that at least if she had not been fully engaged in services, that she was clean. However, she did not take the test as ordered by the court. And
Didn't counsel indicate she finished or completed the drug court?
I don't know anything about her being in drug court, and there is not one line in this testimony or the record that she had completed drug court. So I don't know anything about that. I know they were arrested with the child Gregory in the car, who was also a young child at the time, and they both were passed out and on drugs during that time period. So she may or may not have completed drug court. That I don't know.
Thank you, Ms. Cuomo.
Thank you, Judge.
May it please the court. Walter Burkhardt, attorney for the child. Your Honor, I'd like to address first the issue of permanent neglect. And under the authority of this court in matter of Dagan B, I believe the department did engage in diligent efforts. Diligent efforts aren't perfect or best, but they're reasonable attempts. Certainly the crux of this issue has to do with the concerns regarding, one of the cruxes of the issue of this case have to do with the substance abuse of the mom. And that was arranged to have counseling with Helio, and the caseworkers did check in with Helio when mom was not attending those sessions. Secondly, the department provided numerous services. They provided some housing services. There was a Salvation Army service provider. There was family functional therapy for both the mom and the grandfather, who was an intimate part of this family. And there was psychological evaluation and substance abuse evaluations arranged. And in fact, I would argue it's a logical impossibility, as Appellant argues, that mom cooperated with services that were provided. Indeed, there were many services provided. And then the two other points in this court's decision in Dagenby had to do with, first of all, the regular visitation. And as the appellant concedes, it is true that there weren't supervised visitation services during COVID, but in this family, the grandfather was kind of a linchpin in providing services and visitation for all the kids, including Gemma, and Gemma was at those visitations, so he was supervising the visitation. Finally, as far as informing progress of what was going on to the mom, there were update letters, there were service plan reviews, and in addition to that, both the grandfather and the mom were participating in this family functional therapy where they shared a lot of information about how Gemma was doing. I have to say that mom was not always cooperative. There were periods of time when the department couldn't find and locate where she was, although she had an obligation to provide a current address and current contact information. And they engaged in a lot of diligent attempts to find her, including looking at public assistance records and looking at active warrant lists and jail and probation records. And I believe it's important to be mindful of this court's words in Inri Christian CB, that the parent must assume a measure of initiative and responsibility in overcoming her predicaments. The second aspect of permanent neglect has to do with the failure to plan. And I believe here the court's opinion in matter of Jacob A is very relevant. It doesn't matter if the mom attended programs. That's necessary, but it's not really sufficient. If you're going to provide for the best interests of Gemma in this case, it's important that mom actually learn to accept responsibility and modify her behavior. And the person that's in the best position to determine that would be the trial court judge. And the trial court judge found that her testimony regarding the fact that she was going to keep the father away from these children just was not credible. I'd like to move then to the second issue of effective assistance of counsel. Mom raised that issue at one appearance when counsel was unable to be present because he was at another court proceeding. And there, what the court determined would be that at that point, she believed that the counsel would be able to provide meaningful assistance. Now, she made sure to preserve the rights of the mom and just basically said, okay, we're gonna reschedule this. And then at the next court proceeding, a lot of this has to do with communication between the attorney and the client. And who are you going to believe here? I mean, the attorney as an officer of the court said that my client hasn't been in touch with me for a little while. I don't know what more an attorney can do when they're representing a client. They don't want to throw the client completely under the bus, but they made it clear that they weren't able to get in touch with the client for a little while. It seems that the appellant is relying upon the fact that, no, she was telling the truth. The attorney was lying. She was telling the truth. She was trying frequently to get in touch with her attorney, and her attorney wasn't responding. So then we get to a couple of the key issues. One of them has to do with, there was this written response to a motion in December 2022, and 6 weeks later that wasn't responded to. But my argument is that if the attorney's not able to get in touch with the mom, it would be, inappropriate to put a response that actually could jeopardize the client's position. In addition to that, it would be a reasonable strategic decision not to even respond, not to even oppose that, because the critical issue in this case, if we look at the origins, is the mom, as well as a father, had substance abuse problems. And so it may be better to just say, okay, gonna go along and do the court ordered follicle test. What happened here then is mom said no, and then dad went, then her attorney went ahead and said, okay, you know, she's done everything she should. He made the best arguments possible. She's done everything she needed to do, and we don't believe that this is a necessary component that she has to take this court-ordered follicle test. So the gist of the whole thing is there's two things. There's the attorney-client communication, and what I'm arguing is the attorney, as an officer of the court, was being truthful and honest and saying couldn't get a hold of the client. And to be honest, to even bolster his arguments there, mom a lot of times didn't get a hold of the caseworkers either when they were trying to help her with services.
Yeah, I think we get your
Okay.
argument and laid out in the brief as well, so we will.
If I could just move on to two other points really briefly.
Sure.
And one had to do with freeing Gemma for adoption in accordance with the best interest of the child standard. And the argument that's made by the appellant is that there should be a suspended judgment. Now, a suspended judgment should only be given in a brief when a brief grace period is going to cure the issue. But here we have a case where not only were there issues during this 1 year period, but then 3 years later, by the time we get to this permanency hearing, mom still is questioning, should I do a hair follicle test? I don't believe that the father's a danger to be around the kids. So the question is, has she really learned anything? And is a brief grace period going to cure anything? One final point, Your Honor.
Emphasis on the word final.
I'm sorry.
You may proceed.
Okay. The one final, the point I wanted to make is in the fact that the pleadings were conformed from the October 2nd to the October 8th. And here there was a remedy. I mean, clearly under CPLR section 3026, pleadings should be liberally construed. But if there was going to be a problem, if there was going to be prejudice of some sort, or the appellant believed that it would hinder preparation of the case, then there was a remedy. There could have been an application made for a continuance or an adjournment, which then the court would use their sound discretion to decide, but no application was made in this particular case. And my argument would be that no application was made because there really wasn't prejudice and there wasn't anything that was hindering preparation of the case.
Thank you very much for your argument.
It's your honor.
Case number 308 Wisnowski versus City of Buffalo. Good morning, one and all. Mr. Ryan, you may proceed.
Morning, Your Honors. May it please the court, John Ryan for petitioner appellate Thomas Wisnowski. Your Honors, as I articulated in my brief, it's the matter about equity. There's no doubt that this incident happened. We don't even have the respondents here denying that they're in possession of this information. We're trying to work through legal hurdles to avoid us accessing something that we have a contract that expressly requires them to maintain.
Counselor, I understand your equity argument, but do you have a legal argument? I mean,
Yes, absolutely.
But aren't you supposed to come here and represent to us that you cannot formulate a complaint?
So cannot formulate a complaint
Or in other words, to be entitled to pre-action discovery.
So, Your Honor, if you look
at the laws on that.
So, Your Honor, if you looked at the statute itself, at CPLR 3102, it says disclosure to aid in bringing an action, right? And I think it's pretty clear that actual knowledge of this event would be disclosure that would aid in bringing the action. Where all of this gets muddled up is when you take it down a step from the actual statute into what common law has created with this balance between equity of the person trying to bring the claim and the people they're saying have the information. And so you see these limitations that come in at that point, and it's because these courts do not want people doing scattershot requests for pre-action disclosure.
And that's one of the problems here is I think Mr. Penapinto below, according to the judge, said he does this in every single case he gets. And there was some concern that was a little excessive, but this case, and I understand your arguments and they're well laid out, but is this is a little different under 3102 in that you're not seeking evidence of a lawsuit against fourth generation because you can't sue them under workers' comp, right? They could be, I get your point, they could be a third party defendant down the road, but this isn't to get information to sue them, right? Because there's a bar.
That's correct. The entity fourth generation, we will never be able to sue
City
them.
of Buffalo's a little different. And there you're seeking information, not with respect to the underlying cause of action. You're trying to get by the late notice of claim, specifically the all-important actual notice factor. So this is a little different than this evidence that you're seeking, which is under the contract between fourth generation of the city, the fourth generation had to give them notice of any accidents, incident reports, all that kind of stuff. That's what you want to get to, right, for your late notice of claim issue, right?
Yeah, that's part of
So
it.
that's different than the actual lawsuit against the city. That's just getting you in the door. So these are two procedural issues that are a little out of, I haven't seen cases. It doesn't mean you're wrong. And I get all equity points you're making, but it seems to be a case of first impression here, pre-action discovery to establish late notice of claim rather than the cause of action.
And to your honor, I completely agree with you. This is one of the rare times I can honestly say this is an issue of first impression, not only here, but I scoured Westlaw for cases like this. The only thing that I can say to your honors is, again, the overarching view that what they're arguing is saying that in a situation where there is a late notice of claim, you can never get pre-action discovery. Never. They can have the incident reports. It doesn't matter. They can say that's a bar. There's a couple reasons why that's not an accurate argument. The first, I cited Jamie v. City of New York, which is a Court of Appeals case that says specifically we're able to get paper discovery in petitions like this. That's under CPLR 409 that clearly articulates that. The second aspect I want to bring up is I cite about 5 cases where this exact argument has not been raised, but the late notice of claim is there juxtaposed to pre-action discovery, and pre-action discovery is granted. The one case that we brought up, matter of Simcoiac, the pre-action discovery that they actually got was the reason why this court upheld the late notice of claim. If your honors are looking at something that kind of articulates exactly whether or not this is a purpose that CPLR 3102B can be used for, I would emphasize the case matter of Bonagero, which is a second department case where they basically said, listen, you don't have enough to support your late notice of claim here at this point, but you actually asked for pre-action discovery as well. We're going to send it back. And then it articulates in its decision that the pre-action discovery could yield things regarding actual knowledge. At that point in time, you can go ahead and renew your leave for motion
I understand your suspicions that the fact that they don't want to turn it over means there's probably something there because this could have been over a long time ago. Like they just said, we don't have anything, but
I don't think there's any doubt, your honor.
Right. But on the other hand, you would acknowledge their point that notice of an accident is not notice of claim, right? Like
Yes, absolutely. It has to follow the statutory requirements for what actual knowledge is.
You want to see exactly what they have to see if it's notice of accident or actually qualifies as notice of claim. And then that would give you, it doesn't mean your motion to file a late notice of claim is going to be granted, but it gives you an opportunity to have some evidence on that all important issue of actual notice to go with your application, right? Because the court here didn't rule on this, on the second part, right? The court didn't rule on the late notice of claim, if I remember.
So your honor, you said something earlier about what the court based its decision on. There's nothing in this transcript giving that guidance. The court
I think I had it wrong. I think the court denied it on late notice of claim grounds, didn't deal with the pre-action discovery.
The order itself did deny both requests for relief. It did.
Right.
It's just that none of this was discussed or any of the reasoning, and then that also goes to what one of our primary points is again, we're asking the city of Buffalo for what they had and they didn't oppose the request for pre-action discovery below. The affidavit specifically says, we're just opposing leave for late notice of claim, right? And so, you know, again, like, we're going to these legal bases again for what we're requesting. CPLR 3102B has no restrictions on what we can get. There's no restrictions. It's into the court's discretion at that point in time. There's a case I cited, matter of Barry Laro, that actually goes through and it says, listen, they're asking for something that they would normally get during discovery once a case is filed. Why couldn't they get it at this point in time? And that was with regards to video before a 50H hearing. So they actually had the opportunity to get it. The overarching point is beyond the statute. This is flexible, right? And I also am going to say that this idea that somehow just because you have to prove actual knowledge for a late notice of claim, you cannot obtain any pre-action discovery when something is expressly requiring the other parties to maintain that. It's just simply unjust. I also point back to that Jamie versus City of New York case where it specifically says there is the ability to, with your leave for late notice of claim, to request these documents in writing. That's under CPLR 409, and the court has the ability to grant that relief since the same exact arguments were requested in our notice of motion. Beyond that, Your Honors, it seems like you have a grasp on that just with the late notice of claim argument. I would just emphasize again that there are multiple sections in this record that make fourth generation the actual insurer here of the city of Buffalo.
I think it'll be brought in eventually. Your point is, even if not directly, and so we understand that and we'll take a close look at it.
All right, thank you, Your Honors.
Thank you. Mr. Adams.
May it please the court. What we have here is a situation where the plaintiff alleges he's in an accident, alleges he has an injury. He files a comp claim almost a month later. He works for 3 more months. During that time that he's working, 308 days later, he files a late notice of claim.
As you know, he claims he didn't realize the severity of his injuries, things got worse and so forth. It's not, I mean, maybe he's lying, maybe he's not, but we do see some of those situations, right?
It does happen from time to time, Your Honor. Yeah. I don't disagree with that. But the question that arises for that one is how in the world, I'll start with this one. I have no idea, absolutely none, whether or not fourth generation sent anything to the city of Buffalo. I do not know the answer to that question. I simply don't.
When did pre-action discovery help that?
Well,
this may not be for nothing if you got nothing.
It is pre-action. I mean, what is the purpose of pre-action discovery though? It's to see whether or not you have a lawsuit, not to see whether or not you have what you want for a late notice of claim.
Right, but it's not like there is I get that, but there is a contractual provision in there which gives them a little good faith basis to suggest that there might be something based on fourth generation has to turn things over. So it's a little different than your run-of-the-mill case, but maybe not enough.
Well, I understand that, Your Honor, but in my papers, we highlight the fact that a simple accident report isn't sufficient necessarily to rise to the level. If fourth generation sent us a report, let's just assume that they did, assume that they were made aware, assume that they filed this claim to us. This guy tripped over something and he's still working. That would certainly be insufficient. There's no way if the plaintiff didn't know for 200 days that he was actually hurt, how would anything that they provided us give us actual knowledge, not just that there was an incident, but the court is well, I mean, it's in everybody's papers. The court is well aware of this situation, what that actual knowledge has to be of. It's not just actual knowledge that somebody tripped. That's not actual knowledge of
right. Why would they investigate a trip that didn't result in any harm?
But that's the point really is when you get right down to it, that absent clear abuse of the discretion of the court below, that's not to be touched. And I don't see how this could possibly be clear abuse of the discretion that the court has below.
We do have the ability to substitute our discretion. We try not to do that very often, but there is that.
I don't disagree. That's, you guys have the ropes, not me. But the point is that in this case, the court analyzed all of these arguments, every single one of them. And Mr. Panapinto saying, I do this in every action. Your Honor, I think that the timeline of what happened makes it impossible that anything that, what are there? Two opportunities here. Either they told someone named Devin or Bernard. Either he told someone named Devin or Bernard, hey, something happened. He did that right after the accident. Well, what would he have told him? He would have told him, oh yeah, I tripped over that. He wouldn't tell him I was hurt. I have a hernia. I may have low back problems. He wouldn't have told him any of that. That would not be sufficient actual notice. If there was something from fourth generation at that point, it would not be sufficient actual notice.
Sounds like you sound pretty confident that you're going to win regardless of what we do here.
Well,
but you'd rather win now and save your client all these fees rather than win later and have him incur all those fees, I guess.
Wouldn't everyone prefer to win now as opposed to later?
Yeah.
And as far as sounding confident, I was told early, be right or be wrong, but for God's sakes, be certain. So unless the court has any other questions for me, I think they understand my argument very well.
Thank you.
May it please the court. My name is Maria Mastriano and I represent fourth generation construction in this action. I don't plan to take much of the court's time because it's been well argued and it's also in the briefs, of course, as well. I just want to make a couple points to petitioner's reply brief because I haven't had a chance to respond to that yet. One of the things in the reply brief says that fourth generation did not preserve some arguments. Fourth generation preserved all arguments. I'm going to use two examples here. One, the petitioner is claiming that fourth generation did not preserve the argument. The petitioner is not entitled to pre-discovery action because he could not set forth a prima facie cause of action against the city. This is preserved in the record and fourth generation's affirmation on page 266 to 267, which is one of my main arguments. Plaintiff may not seek pre-action discovery to determine if they have a cause of action, just different words, same thing. Second, petitioner contends the fourth generation's argument that pre-action discovery requests are culpably overbroad and unduly burdensome is unpreserved. If you look, the record on page 268, footnote 1, I have noted, please note, many of petitioner's demands are palpably overbroad and unduly burdensome. But what I'll tell you is what's not preserved is something in the reply brief, this argument about CPL 409. If you look in the order to show cause, the only thing that is cited there is
CPLR 409?
yes,
Okay.
is CPLR 3102, and that's on page 17 of the brief, Your Honor, of their brief. Another thing I'd like to address is fourth generation is not an insurer, okay, of the city. There's an indemnification clause like there are in all of the contracts, and that'll be decided at a later point, right? Whether we will accept that indemnification or not. But throughout the papers, there seems to be this innuendo that there's a shell game going on. There's no shell game. We're not an insurer. They're 7 months late when they knew 23 days in. And what's really happening here is what Your Honor said right at the beginning, it's jumbling all into this amorphous of what's fair and what's not. What we're here to talk about is to laser focus on the legal standards that accompany pre-action disclosure. There are 3 reasons to preserve evidence. That's not argued here. There's not one thing that's listed where they got to preserve something. To identify the parties. They're saying they already know the parties. Or finally, to frame the complaint. And plaintiff's counsel at oral argument in the lower court said he didn't need to frame the complaint. We know, and I'm quoting, we know what our complaint is. So what we have here, in my opinion, is clearly a fishing expedition. Another thing that plaintiff's counsel said in the lower court is, listen, if the city of Buffalo didn't have notice of plaintiff's claim, then that case can be dismissed. So we're fishing to see if they're fishing to see if they have a cause of action. That is specifically prohibited by CPLR 3012C.
And for these reasons, and the reasons that are laid out in the briefs, I respectfully request that the court affirm the lower court's decision. And I rest on my papers unless the court has any questions.
Thank you.
Thank you.
This case for argument is 309 Wheeler versus Brand Safeway Industries LLC. Mr. Adams is already here. He's already here, and we're waiting for this Mr. Collins.
Yes, sir.
And then we have Mr. Vini. All right. Mr. Collins, you may proceed.
Thank you, Your Honor. May it please the court. My name is Ethan Collins. I represent plaintiff, appellant, respondent Brian Wheeler. This case has been briefed extensively, and I'd like to get right to the point. We are asking the court to modify the trial court's order. We believe the motions for summary judgment were wrongly decided. And so we're asking the court to grant plaintiff's motion for summary judgment under labor law 241-6 premise on a violation of 1.7F. Grant plaintiff's motion under labor law 240-1, which would require reversal of the dismissal of plaintiff's claim under 240 that was granted to the defendant, as well as reinstate plaintiff's common law negligence claims against Brand Safeway, scaffold contractor. We're also asking the court to adequately address the negligent spoliation of evidence in this case. So I'm going to start with labor law 241-6, and I believe the court below erred in not granting plaintiff's motion. I think
Well, I think we know, because, and believe me, this is going to take a long time. We're going to be here for an hour on this case probably. So I apologize to the lawyers to follow. There's a lot of issues here. In 241-6, we have the regulation that you rely on 23-1.7F. They rely on 23-5.3F, something like that. The issue here is, was it, given the nature of the work, was it feasible? That's not the word in the statute, but was it possible to have stairs ascending this passageway, right? The regulation you rely on doesn't deal only with scaffolds. Their regulation deals with metal scaffolds. Yours deals with vertical passage. You're telling me that as a matter of law, based on this evidence, you met your burden of establishing that there was room for stairs, and in opposition, the defendants didn't raise an issue of fact on that.
Yes, Your Honor.
And would you agree with me that the issue of whether the stairs were feasible under 23? Now, look, they don't even think 23-17F applies at all, okay? They think it's trumped by the 23-5, but assume you're right on this. It's not just whether there's room enough to put stairs in. It's whether, given the nature of the work, they might have trucks coming in, trains, or not, cranes, man lifts. Is it absolutely clear as a matter of law that they were feasible? Now, I know they did it after the accident. They put them in a couple of weeks later, but where in the record is it established conclusively that stairs are feasible? And then we'll get to whether the defense raised an issue of fact.
Sure. I think the court is correct. It's not just whether it was feasible, it's whether the nature of the progress of the work prevents their installation. So I think on page 23 of my brief, I laid out all the testimony from all the witnesses. All of them agree that there was nothing about the state of the project or the nature of the work that prevented the installation of stairs.
At what time? When the scaffold was erected?
This is for the 2 weeks before plaintiff's fall. So from August 1st to August 16th, 2019, which is the date of the incident. I asked specifically about that period to the foreman for the scaffolding company, to the project manager who quoted the project and actually fought for the installation of scaffold stairs at the very beginning of the project. I asked the safety director for Hull, who did the investigation and actually abated the hazardous condition by installing scaffold stairs within a week, and nothing about the scaffolding had changed. I asked the site safety director for Hull, that same 2 week period. I asked the project foreman for Hull. I asked the chief marine engineer for Maid of the Mist, and they all agreed that within that 2 week period, There was nothing about the state or nature of the project.
There was space enough, but how are they in a position? It's a means and manner case, not a defective condition case. How would they know all the work being done and what other equipment needs to come and go to the work site? How would they be in the position to know?
So Brand Safeway was in and out of the project, essentially changing the scaffolding. And Brian Krasowski was actually there for, he said he had been there for 5 days during that period. And so he was on site and evaluating the scaffolding. And I asked him specifically, the state of the project at that point, was there anything about the state of the project that would have prevented stairs from being installed? And he said, if that was something that Hull wanted, then no. And so he was there on site and actually evaluating the scaffolding.
He was trying to get, it'd be $1,500 more a month. He wanted the stairs. But, all right, so let's assume that we agree they met the burden. You're telling me that there's no issues of fact by any other witnesses here, that it was feasible, given the fact that it sounds like the scaffold, the work progresses and it moves down the line. And that's one of the arguments, right, from the defendant. But by the time they put the stairs in, they say, well, it's not the condition when the plaintiff fell. Does this moving scaffold issue, does it raise an issue of fact?
No, because if the court looks at it, that testimony was specific to when they were building the scaffolding around the boat. So this project began in the early spring of 2019. And they had to drop the pieces of the boats in, begin constructing them, and then at some point, the scaffolding system is built around each boat. And during that 2-week period where the scaffolding has been built around each boat, there is plenty of room and there is nothing about the state or nature of the work at that point that prevented stairs as a means of access to the working level above ground, which is the boat. And I think it's important to note that the plaintiff only worked on that top level. He was not, working from the platform of the scaffolding. He was only using
This is access to a work site, not working on top of the platform, which is why you think 23(1.7) F applies.
Yes, it just so happened to be that they decided the only means of access to the working level above ground was going to be the scaffold ladder.
Right. So
but I don't think that
there's no witnesses when Mr. Vitti and Mr. Adam gets up here. They're not gonna. There's no evidence to the contrary from any of their witnesses that it wasn't feasible.
No, Mr. Adams attempts to raise the testimony of Mr. Motak, who is the foreman for Hull, and says, they were moving the scaffolding and so forth. But again, that testimony refers to earlier in the project when they are building the scaffolding around the boats. And Mr. Motak was asked directly, would you have any reason to disagree that there was nothing preventing scaffold stair towers from being installed during that 2-week period before the incident? He said, I would have no reason to disagree.
So you want summary judgment. Judge Pace erred in finding an issue of fact there. You want summary judgment. Now, with respect to the subcontractor, Brand Safeway, do you want to get to that agency issue now, or do you want to, what's the order of your argument?
I think that can be addressed in terms of the Labor Law 200 common law negligence claims, because I think it's a lot of the same issues, but I'm happy to address it now.
Because it applies, can you be an agent? Can the sub be an agent under 241(6), but not 240 sub 1 or some of the other, or is it all or nothing?
I believe it's as long as it's within the scope of the work delegated to them. And here it has to do with the access to the upper level.
That's
So
what I'm saying.
I think it's all or nothing.
Right, because I think Judge Pace said possible agent under 241(6), not under 240 sub 1, right? That's not logically consistent. Either you're an agent under that Russian case, the Court of Appeals case, you're in under the labor law as a agent of a contractor or the property owner for all, or you're out for all.
I believe that to be the case,
Right.
yes.
So the Judge Pace was wrong on that.
I believe.
And you want him to be an agent for both.
I think he was an agent for both. And I think the other point about Judge Pace's decision and Judge Pace actually recognizes that all of the witnesses agreed there was nothing about the state or nature of the project that prevented stairs. And then he concludes there's a question of fact on that issue. So I had a hard time. But I believe the witnesses there, the testimony is clear and it's all laid out on pages 23 and 24 of my initial brief.
Getting back to the agency issue against Brand Safeway. you agree that the only way an agent is, subcontractor is an agent of a contractor or an owner is if there was a delegation of the duty to supervise or control the work being done or the area, right? It's got to be, and would you agree with that?
The work that was assigned to them, yes, it has to fall within that for
You
agency.
concede there was no delegation of authority to supervise and control the plaintiff's work.
I concede that.
That's out.
Yes.
So now we're left with this area supervised control, which is not in the Court of Appeals case, but we, Piazza, some other cases, we said area too. Okay, so let's say that that's valid. Where do you see any delegation of authority from Whole, Maid of the Mist, or New York State Power Authority to Brand Safeway to control and supervise an area? Now, I know you're going to say, well, we have a subcontractor that said they had to build a scaffold. I get that. But where in that subcontract agreement? Well, first of all, do you agree there was no oral representation, no oral delegations?
Yes, I believe I agree with that.
So you're relying only on the subcontract, paragraph 9, the safety. It says something like safety rules or safety regulations, right?
I believe there's a portion in the contract wherein Brand Safeway agreed to protect not only its employees, but those of the contractor with respect to the design, installation, and maintenance of the scaffolding system.
Was that for indemnification? Or was that?
I think it was just a broad blanket to protect all those workers.
Where in that subcontract, which I have right here, if you could direct me to any language that specifically, because you and your brief rely on paragraph 9 safety laws.
Yeah, so I think
1251. Where in that paragraph 9 does it say anything about delegation, supervision, or control over an area? Or feel free to rely on any other provision of the subcontract where, because again, we need a delegation of authority to supervise and control from Whole, right?
Correct. Or Maid of the Mist.
And you're relying, you acknowledge there's no oral delegation, so this is it. It's got to be in here somewhere. And I'm asking where in here is the delegation of ability to, not a delegation of the obligation to build the scaffold. We know that's what they were hired to do. But to control, to supervise and control that area on an ongoing basis. Well, that, I might have caught you off there, so that might have been unfair, but in your brief, you rely on
we do rely on paragraph 9, and it's our belief that the fact that they agreed to protect not just their own workers, but the workers of Whole and any other subcontracted workers, and to install or procure additional safety measures at its own expense, which requires monitoring and controlling the area that they were assigned to perform that work.
So the subcontractor says to the general Whole, here are the various options. You get the stairs, you can get the non-stairs, you can get a rigger. The general says, we want the cheaper option. We want the scaffold. And your client then is supposed to say, no, I'm going to build it with stairs and with other safety devices like apparently some outrigger that, and you don't have to pay for it, General, because I got to pay for it now. I mean, that's seriously what they were supposed to do here.
I think that based on the contract that they were supposed to comply with all applicable safety laws, I think as scaffolding experts, which they hold themselves out to be, that they should know. And I asked Mr. Krasowski, did you know what the law of New York State is with respect to vertical passage? And asked him if he should know about that. And I think that they have a duty to comply with that and should insist on stairs when it's feasible.
Right, and pay for it themselves. But how would they know under 23(1.7)? Stairs are not categorically required. It depends on the nature and construction of the work. You agree this is not a means and matter case. Like, how are they supposed to know when they put this up, like down the road? Well, it might become feasible. It might not become feasible. I mean, that seems to be within the province of the general. And again, I don't see any words delegating, but we're gonna, as long as I know what your claim is, you're relying on one paragraph for the delegation for the agency.
For the agency.
And we'll take a look and see if that, so we can move on now.
Sure.
The big one to me is the 240 sub 1. Was there proper protection? Your client's position is that, the trial judge has dismissed it. And that's, I think, the least sound of the three options here, but you're saying you're entitled to judgment as a matter of law because the scaffold as built without stairs failed to provide proper protection. And there's no issue of fact on sole proximate cause, correct?
Yes, Your Honor. Because if there is a violation of 1.7F, which we believe we have shown and proven, and that his accessing the upper work level is what caused him to fall, you cannot have a statutory violation and the plaintiff be the sole proximate cause. And so that's the basis for that argument. I think the court erred in dismissing plaintiff's case under Ward, regardless of its decision as to 1.7F, because this court in Ward, in somewhat similar circumstances, found that there is a question of fact as to sole proximate cause, even though it found that the defendants in that case had complied with 1.7F.
So you would have to find there was a statutory violation that the stairs weren't built, though, to agree with you, though.
I believe to grant plaintiff's motion that there was not proper protection, you find that there's a violation of 1.7F, which therefore makes it impossible for the plaintiff to be the sole proximate cause.
So 241 and 241.6 are coextensive. You win on the stairs issue under the regulation, you gotta win under 240(1) in your view.
Correct.
What if the plaintiff fell without carrying up any items, heavy items? He's going up, 15 feet on a stairs attached to a scaffold to the work to the boat. He falls, not carrying anything. Is that?
I think it's the same case. I think that's why the legislature, when they passed the regulation, requires stairs, ramps, or runways, because it's safer. The fact that they had dozens of people on this job and they were supposed to climb a vertical ladder to a working level 20 feet above the ground 8 or 9 times a day, up and down it with no fall protection, was not proper protection.
How was he supposed to get up there not carrying something? They had harness, tie rope.
That was not part of this job. Both Motak, who was the foreman for Hull, and Corey Parrish, who is the chief marine engineer, testified that they never wore harnesses or lifelines on this job. That was not part of the custom and practice on this job site. Nobody wore them. They were not, you can't say that plaintiff was expected to wear it. So there's nothing to indicate that he played any role in, failing to use a harness or retractable when his boss wouldn't use one himself.
So your client carrying a spool of heavy wire is irrelevant.
I think
he
so.
wins even if he's going up empty-handed.
I think so. Based on the fact that they did not.
What if he doesn't maintain 3 points? He could really do 3 points of contact with the wire spool, but what if he's climbing up and he just falls?
I think that falls under the precedence of cases where it's, choosing one manner to climb or following instructions on how to perform a task is just evidence of comparative negligence, which is not a defense to 240.
What if we know, because here there's a combination. It just wasn't he had to climb up and not walk upstairs. It was, he felt he had no other option but to carry that 30-pound spool of wire up, right? The defense, of course, say there's a rope we can see, a pulley, said he should have done that, among other things. There's a silver lift, there's other things, but the rope seems to be the primary thing that he ignored. Your client, I know, says, no, that's not a safe way to do it for a lot of different reasons we don't need to go into, but let's assume that it was a safe way. And they told him, never carry anything up the stairs, always use the rope. And he says, no, I'm going to carry it anyways. So approximate cause?
I think that presents a different argument, and it's not the facts of this case, in that he indicates he was never told not to carry anything up the ladder here.
Well, they say he was.
Well, that would be a question of fact.
Right,
Yeah.
right. Yeah, so I'm
Question of fact, the sole proximate cause, correct.
I'm just speaking for me. I'm beyond the court got it right as far as dismissing it. I'm between issue of fact and you want judgment as a matter of law.
Correct. And I think this folds more so back into the 1.7F. I think the court is correct that generally whether a device provides proper protection is a question of fact, except where we have a violation at the same time, showing that he didn't have the mandated means of the access.
So, but if we were to disagree with you or agree with Judge Pace, there's an issue of fact on 241-6, then you're conceding there'd be an issue of fact on 240-1.
I still think that he was not provided proper protection because he wasn't provided with a harness and a lifeline, and those are reasons that he fell.
Okay. Let's move on to, we did agency, right, we've done 241-6, we've done 240-1. Let's get to the sanctions issue, which I read your motion below the hearing and your brief. You don't care about what Judge Sedita cared about. Judge Sedita found no spoliation violation. He was upset with the 4 cell phone videos of the actual accident that weren't disclosed, right?
Correct.
And that was discovered the night before the spoliation hearing. You're not asking, you never ask, and you take no position on the sanctions that were awarded personally against Mr. Adams.
We never asked for sanctions against
Do you
counsel.
see any evidence in this record that Mr. Adams intentionally withheld or violated a court order with respect to those videos on Mr. Mesner, I think his name is, Mr. Mesner's cell phone?
Intentionally, I can't speculate as to that because I don't know his intent. I think.
But you have no reason to believe he had knowledge of those?
Other than what he says in his papers, no, I have no reason to believe he had knowledge of those. I think this goes back to the duty of the defendant.
So you're not here defending the $10,000 sanction against Mr. Adams?
No.
You want judgment as a matter of law on 241-6 based on spoliation with respect to the 15 other cameras at the work site.
That, and I think the spoliation of all of the video evidence also goes to plaintiff becoming prejudicially bereft of defending against sole proximate cause, because that would have shown how the work site was operating, whether other workers were climbing up and down the scaffolding, carrying things, what devices were available.
Would have showed feasibility on the stairs too.
Exactly, would have shown everything.
Okay, so you're here about spoliation. Mr. Adams here is about the sanctions, about the discovery violations. So we got sanctions and we got discovery violations. Sedita ruled against you on spoliation. That's all you care about.
Yeah, I think the sanction was not the proper remedy for what happened. Correct.
So Sedita's point is when they're making the copy on the cell phone of the video, he couldn't burn a CD of it. How would he know at that, Mr. Mesner, at that point, that these 15 other cameras at the Maid of the Mist work site that don't show the fall, show all these things? Like, how would anyone even anticipate this 23-1.7 issue with the stairs?
Well, I think Mr. Schull, who is the comptroller for the Maid of the Mist, he testified at the evidentiary hearing that 1, he was aware of the fall. 2, he went down to the dock that day. He knew there would be a claim because he placed his insurance carrier on notice, and then he placed Hull's insurance carrier on notice, they had the indemnification agreement with.
Right.
And they requested everything with respect
to the accident,
with respect to the case. And he knows there's cameras covering the entire.
Right, but would you agree with me? The only reason those other cameras are relevant is because 4 years later, somebody brings a claim under 23-1.7, which none of us, at least me, you probably knew about it. Most people have no idea what that statute says, or that it's not a statute, it's a regulation. Like, it seems a fetch to say Maid of the Mist is going to be like, let's just give them video of the fall because these other cameras show all the stuff where nobody's there. They might be relevant as whether we can put stairs in. That seems.
I think putting the law requires that you put a litigation hold. You at least can preserve all that video and then figure out which is relevant later on. But they had a system. They could have just put a hold in place and said, preserve all the video that we have accessible now.
Do you have photographs? Didn't you or someone from the firm go there and take a perch from the hill and get everything that?
Yeah, Your Honor, Messer testified that he took hundreds of photographs of this job site. He's the safety engineer, and he provided them to Maid of the Mist. Those were never produced in discovery. We learned about that during the evidentiary hearing. The only reason we have proof of what the job site looked like is because I went to the gorge and took those photos over top of the gorge a week after this happened. And so not only did they not preserve the video, but they didn't turn over at least any photographs of the job site that they had hundreds of. I look at this as So this was a very serious accident. It's a burst fracture. He's seriously injured. Everybody knows that. They put the insurance carriers on this. This would be like if a plane falls out of the sky and the airline decides, well, hey, we're going to blame the co-pilot here, but we're only going to preserve the last 30 seconds before the plane hits the ground. Wouldn't you want to figure out why it fell out of the sky? You got to know the whole
I don't
picture.
get why those 15 other camera angles that show remote parts of the work site would explain why this guy fell off a ladder.
But it would go to the custom and practice on the job site. It would show whether other safety devices were available, whether a van lift, whether workers were climbing up and down the ladders carrying things. And because we have testimony saying that they were instructed not to do that, but they could show that that's not the case on the video. So
then we got indemnification. That's not that, well, that's against, do you have a dog in that fight between Hull and Betry?
I don't. And the other thing I'd just like to note is, we believe that we have proven that there was a violation of 1.7F and 241.6, and therefore also 240 should be granted. I think if this court grants plaintiff's motion under 240, then this sanctions issue may become moot, because then we can proceed to a trial on damages, which we believe would be just and what we're entitled to. If the court denies plaintiff's motions and we have to go to trial and defend on sole proximate cause based on a cherry-picked video, and they didn't do their duty to place the litigation hold and preserve all the relevant evidence in this case, I think that's not just, and I think that's not an appropriate sanction. It's sanctioning counsel, which is why, we ask for the answer to be struck.
Let's assume that it should be a sanction. Not against Mr. Adams.
No, against the defendant. Yes.
Right. Like how does he get hit for 10,000 for something Mr. Mesner did?
I don't know. That's because Judge Sedita couched it in terms of ignoring his discovery order as to why he was.
Yeah, I think the basis was he thought Mr. Adams should have asked sooner for something that he thought he already had. So I guess he said, you should say, are you sure you gave me everything? I don't know, but we'll hear from Mr. Adams on that one.
Yeah.
Thank you.
Yeah, sorry.
Anything else?
No, just that if we believe that if we haven't proven 241.6 and 240, it's because of the negligent destruction of evidence.
Gotcha.
With respect to the 200 issue, I think we kind of discussed that earlier, so I'll just rest on my brief for that.
Well, thank you.
Thank you.
Mr. Vidi's next, or you're going to go next, Mr. Adams? I guess it's up to you. It doesn't matter to me. You're on the calendar next, but you can cede your time to Mr. Vidi first.
Morning, Judge Lindling, members of the court. Judge, based on the robust knowledge the court has of our case, would you like me to address certain issues first based on what you've already asked Mr. Collins about?
Well, would you agree that the plaintiff's relying, and maybe Mr. Adams to some degree, they're relying on no oral delegation for the agency issue. They're relying on one provision of the subcontractor between Hull and your client, Section 9, the safety laws, I think it says. And in your view, there's nothing in there that delegates.
100% correct. And there was no actual delegation of any responsibility, authority, or direction, supervision, and control.
There was delegation of the duty to build a scaffold, but that's the whole contract.
Pursuant to Hull's and the owner's request, which they did.
Right. Now, they say there is, so I think I'm okay with that. Did you agree that your client's either an agent for for labor law in general, or you can't split it up?
Cannot be split up. We are not an agent for either, and I can address both the issues raised by your honor when asking Mr. Collins.
Sure.
Rustin v. Picciano, obviously, Liquors versus Aaliyah, that's been on the fourth department for 40 years. Absent any direction, supervision, and control of a subcontractor vendor, there is no exposure or duty pursuant to the New York State labor law. So that is black letter law, as clear as the day is long. Also, factually, the record is 100% clear that our client, Brand Safeway, did not direct, supervise, or control the plaintiff's work or the manner of work he was doing or the area he was doing at or near the scaffold when he
You
climbed
agree
the
that
ladder.
if it's the area, no one disputes supervision and control over the work of the plaintiff's work, that's out.
Yeah.
Are those property defects cases only? Because we don't have one here, right?
No.
We have.
No.
Would you say that we extended Russian to include area?
Yeah.
Right or wrong, but we've done it. Those area cases seem to be property defect cases.
Yes. That's my understanding, Judge. But also with the area, Judge, we had no control over the area. We weren't even present in the area. And the plaintiff never saw Brand Safeway's people on site. So there was absolutely no involvement by Brand Safeway in the area where the work was being performed at any time it was being performed.
Weren't they on the site to move the scaffold at times?
When requested by the agent of the owner whole, who controlled the method, manner, and means of work and the entire work site and the work of every laborer, including the plaintiff. So that it goes back to the history of the labor law. The owners and general contractors, when they built the Brooklyn Bridge, had control. Unless we're asked or given instruction, because it's, as you said, Judge, we have no knowledge about feasibility of when the client, in this case, Whole and Maid of the Mist, would want a scaffolding moved or a stair tower, any changes made. They control that because they know what they're doing. Also, Judge, we weren't involved with it. We didn't become aware of this case until after the lawsuit was filed. So even when the stair tower was requested, our client didn't have any knowledge or information was related to an accident. That came much later, Judge.
Let's say that you get out as an agent against the plaintiff.
Yes.
You still got the indemnification claim under Section 8 of the subcontract, and we've got Maid of the Mist and the Power Authority seeking indemnification, not Whole, right?
Yes. Yes.
So you want to be heard on that. They want conditional indemnification. If they get hit for, well, we should have had stairs. They say that's on you under Section 8, not Section 9.
Yes. Judge, I disagree with that because when you look at the contract, it's very clear that, and it's been admitted by counsel for the Maid of the Mist, that there was nothing wrong with the scaffolding. We didn't do anything wrong. The contract language has the cause by language in there, and there was nothing wrong with the statute. It was a misuse of the ladder by the plaintiff. So for them to even keep any type of indemnification is premature, and it is not supported by the record before this court. And there has to be some evidence that our client proximately caused these injuries, and there is none of that in the record to date. And also his burden is to prove that it was based somehow in the performance of or lack of performance by Brand Safeway, which is not present in this case. Mr. Adams creatively tries to say that we could have put a stair tower on there, but that is untrue because Whole and the owner controlled whether or not they needed a stair tower. As you pointed out when you're questioning Mr. Collins, we don't have any understanding of moving materials, cranes, operation on when they want a stair tower or not.
Or when they're done with the work.
Correct.
So let's say we agree, well, we've addressed your defensive actions from plaintiff against you.
Yes.
I'm sorry, with respect to the agencies. Now there's issues that you and Mr. Adams are aligned.
Correct.
Do you want to, I know he's going to hit those hard on 241.6 and 240.1, but you also have an opportunity to be heard on why plaintiff loses on those.
Yes, Judge, thank you. And Judge, it's my understanding the court has our arguments with regard to agency, so I won't go any further there. Judge Pace got this right as it relates to Brand Safeway with regard to both agency and also with regard to the plaintiff's sole proximate cause of the accident. And when you look at the standard and when you look at what it was come down from Blake, from Cahill, and also what this court did in Kimball, because I think that is that's very on point, that, and then the Boncanetto case, which I believe that the 4-prong test in Boncanetto has been met in this case, where the plaintiff's cause of action, assuming arguendo that we're still in the case or not in the case, it should be his conduct was the sole proximate cause. He was a highly trained and skilled Boilermakers union. He had OSHA training and certification. He had experience climbing up not only this work site, but multiple work sites. This man had climbed a ladder up to 100 feet in his
Right, he was doing it
career.
up and down 9 times a day, but what if, I know you dispute this on a factual level,
Yes.
but the plaintiff testified in his deposition, it wasn't feasible to put that spool into the bucket with the rope for various reasons. Too heavy, bucket too small. Let's assume that there's no other way to get that spool up there, and he's got to carry it up. That's a labor law 240 sub 1 claim, right?
But does not apply to this case because there were other means to get the
Right, so
spool
that,
up.
so, yeah, so
Yes, there
the
were
question
other
is,
means.
is there an issue? It seems like it comes down to, is there an issue of fact on other ways to get that spool up there in a safer manner? The rope seems to be the predominant safety device, if you want to call it that, to get the spool up there. I know there was, the boom lift is out, right? There's some talk about boom lift. You're not saying that he should have used that.
No, but there's JLG lift, there's scissor lifts, there are other ways to do it. He could work with a coworker and come up with another manner of hoisting. So they were up and down, many workers on the site.
So there's a man lift, but it's elsewhere at the site. We get to these situations that he can't, just generally at the site, but that's really what it comes down to here, right? Is could he have used another method to get that spool to the top other than carrying it up? If there was, then you got a good argument that, hey, not only on sole proximate cause, but on proper protection.
Yes.
Because you don't, given it's only 15 feet, you probably don't need tie-offs and all that stuff for the ladder. But in any event, that seems to be the issue, right? Did he ignore safe ways and feasible ways to get that spool to the top other than carrying it up, which was highly unsafe?
Yes, Judge, but I also don't want to concede the fact that all the other boiler makers were doing the exact same type of work and getting the exact same product up to the elevated work site to do the welding on a daily basis. So we know it's feasible. So I disagree respectfully that there were other feasible, safe methods because every other boiler maker before and after him used the same manner to get their welding tools out.
I wasn't saying that there were, I was just asking the question.
Oh,
he says that there were. He says there were no other feasible ways.
Right. And my position is that's not true because they were doing it other ways feasibly and safely, and they were using the same ladder to get themselves up and down. So that I think that is very clear because we know the other workers were doing the same work he was doing for the Boilermakers, and they were welding and they needed welding spools and they got them up there safely and they all climbed the ladder safely. I think it's also important, Judge, when you talk about that, is that there are multiple different ways that it could have been done safely because we know it was done safely. The record does not have every incident of it, and that would be, of course, if there were a trial on that issue, but clearly every other, and Mr. Motek, talked about the fact that Mr. Motek was working with Maid of the Mist, and they determined whether or not they needed a stair tower. And he honestly said that he didn't. They didn't need it and they didn't need it afterwards. I think it's important to note, Judge, that Mr. Motek, who is a very experienced Boilermaker, he said the cause of the accident was, unfortunately, Mr. Wheeler's careless and negligent decision to climb a ladder knowing that he could not maintain 3 points of contact.
Judge Pace bought that argument.
Pardon me?
Judge Pace bought that argument.
Yes, Judge. And because it's a strong argument, Judge, because it's an extremely strong argument, because he made that decision. When you look, and the video, how often does this court have video this clear and concise, reasonably speaking, where you see the rope there next to him, you see the ladder, you see him contemplate what he's going to do, and he knowingly climbs the ladder, knowing to use Mr. Motek's work, we have to hop because you can't, and he was trained in this. And they had Hole and Maid of the Mist. They had daily safety meetings. They talked about ladders and climbing.
But again, you would agree if that safety rope, or not the safety rope, but the pulley rope wasn't suitable to get that spool up there. The spool was too heavy, too big. The handle would have broke. Then that weakens your case a little bit. Then he's like, well, I got no alternative. I got to carry it up.
But I can't give you that, Judge, because the other workers did it safely the same way. So
with the same weight and the same item?
That was a standard spool. It's
all these other Boilermakers basically held their 3 points of contact by carrying the spool of a wire rope?
I don't know that I don't believe
no one else got hurt.
I'm saying they likely didn't, Judge. I'm saying they didn't. I'm saying that they got their spool up by an alternative means, whether it was working with others, whether it was hoisting it. But I'm saying
I thought the impression I thought you were making was that everyone else used this ladder
safely. by maintaining 3 points of contact. They were not carrying spools. We have no information that anyone else carried a spool up that ladder because it would have been unsafe. It would have been a violation of OSHA. It would have been a violation of their training and
Do
safety.
we have
rules.
anyone in the record who says we carried a same spool up on the rope pulley?
It's a very deep, thick record, Judge.
Yeah.
I can't say, I can't recall that right now.
I didn't see it, but it is
You know,
thousands and thousands of pages.
But I know it was there and I know it was being used.
How'd they get it up there then? If you don't know if anyone's using the rope. And you're saying that Mr. Wheeler's the only one that.
Judge, I'm saying I don't recall someone testifying that they used the rope, but I recall testimony that they were using the rope and bucket to hoist materials up onto the scaffolding to the elevated work site to do their work daily.
You have,
Maybe there's other videos would show that.
Which we do not have.
That's a good point. That's
And
a
actually,
good
Judge,
point.
we do not have the evidence. We do not have, Judge.
Because of the spoilation, Mr. Collins would say, but the sanctions issue, you don't seem to have a take on that one way or another. He didn't sanction you, the judge.
My position on that, Judge, is that if this court strikes the answer of the made of the missed defendants, then the cross claims they have against my client are dismissed as a matter of law.
That's spoliation. I'm talking about the cell phone. That was what Mr. Adams got sanctioned for, not spoliation, but for the cell phone. You don't.
I'm not taking.
And the cell phone got turned over eventually anyway.
Yeah.
And it showed almost everything identical, maybe a little lighter on one, but you don't wish to be heard on the sanctions issue here.
I will not take a position on that, Judge, other than, as Judge Montour said, since he raised it, we would always want as much discovery as possible to defend our client in a case.
Okay, thank you very much.
Okay. And Judge, are there any other issues or questions?
Well, there's one outstanding. I think Mr. Adams is going to hit this one pretty hard. It's the relationship between the regulations of 23-1-7F and 23-53F. He says the metal scaffold one, the second one supersedes the first one, and you, I know, have that position too.
I do, Judge.
You want anything that?
I just briefly, if I can, and then I'll defer to Mr. Adams. I don't mean to take too much of his time. I would point out that that is our position, that what Mr. Collins is trying to do is to ask this court to be a quasi legislative branch by the change in application or the seeking the application of 23-17F when there is an alternative specific statute, which is the primary one, because 1.7F is general, specifically 23.53F is specific.
You don't think they could possibly work in harmony? There's a way to read them. If you have a metal scaffold that's more than 2 feet above the ground, then you can use stairs or ladders, right? If it's a vertical passageway, however, then you need stairs if it's feasible. If there isn't, can't they be reconciled? They're not mutually exclusive?
I think, Judge, that when we look at the facts in our case, based on all the issues this court has raised, that you can't make that decision at this stage, because really when you narrow it to its simplest core form, the ladder was safe for its intended purpose, the scaffolding is safe for its intended purpose. It's a misuse by the worker. And I think the Bianca Netto case illustrates that to the court. You can have a stair tower and a worker can choose not to use it. And I think we've met I think we've met that standard for the Court of Appeals when you look at sole proximate cause. So when you look at that in this case, the ladder was safe for its intended purpose. He doesn't know what caused his fall. He testified that he missed her wrong. His excited utterance to the ambulance and medical personnel was, "I missed her wrong." To his coworkers, "I missed her wrong." The evidence was, unfortunately, Mr. Wheeler made a terrible mistake in this case, Judge. And then when you look at the statute, I also would point out our expert that we retained, Mr. Glabe, is authoritative in this area, and the court can't consider it despite what Mr. Collins said. Mr. Glabe is very experienced, and the Court of Appeals has relied on his expert opinions in other labor law cases in finding and making determinations. And I thank the court for your time.
Thank you. Stress.
Please, the court. I don't even know where to start. So I'm going to start with I'm going to start at the back end and work my way forward, if you will, with the sanctions. It appears that no one has a position on sanctions. If you read what Justice Sedita said, it appears that he sanctioned me because I wouldn't tell him what my conversation with my client was.
Can I just kindly ask you to slide over so everyone at home can see you?
I'm sorry.
That's okay. Thank you.
That's privileged conversations. Any communication I have with my client is 100% privilege, and that privilege is not mine to violate. That is my client's to tell me I can.
Justice seemed to be upset that your paralegal had asked the question of Mesner the night before in the email, do you have anything else? And lo and behold, he does. Sedita seemed to say, I'm not saying I agree with him or disagree with him, but if you had exercised due diligence and asked him that question earlier, we would have had those other videos earlier, right? He seemed to be upset about that.
Yes, he seemed to be upset about something.
Among many other things.
But it wasn't specifically my paralegal didn't reach out to him to say, do you have other videos? My paralegal reached out to him to say, do you have time to speak with Mr. Adams about the video? Because we noticed that you have been subpoenaed by the plaintiff to appear at an evidentiary hearing. And we tried to reach out. We found him the morning before, something like that. I'm driving. I was in Dutchess County. I'm driving back when my phone rings and I hear, oh my God, David, you're not going to believe this. He actually has other versions of the same video.
There's still nothing terribly different, maybe a little wider view that would be relevant to the 241-6 claim slightly. But in any event, so he awards sanctions against you, not the client.
Correct. And he did that because I refused to
answer his question.
His question was, what did you ask him? When did you ask him? What we and I can't answer that question that's posed to me by the court because I'm bound by the privilege.
The judge's decision, he started with the law, 3126 of CPLR, sanctions for discovery violations. The law says right in the plain terms in the case law that the violation has to be willful. He then goes on to find it wasn't willful, right? And then he sanctions you anyways.
Yes.
That's one basis in your view to vacate the sanctions.
Yes.
The other basis would be he hit you for $10,000 on the theory that plaintiff had to expend $10,000 for the spoliation hearing that was going forward anyways. And
spoliation that he denied. So yes.
Right. And so Judge Sedita says there's no spoliation, but that spoliation here was going forward with the same witnesses, same attorney's fees, everything. So there's no causal relationship between your alleged discovery violation and the incurrence of attorney's fees. So we get yet another basis to vacate the fees.
Yes. Not to mention that none
of
the parties asked for it, and none of the parties are standing up here supporting it.
Right. So we can move on then.
Okay.
Big issues are the 240. I mean, you seem to want to keep that subcontract in there pretty hard too. So you want to be heard on that?
Yes. And specifically, it has to do with Brand Safeway and whether or not they're an appropriate defendant in a New State labor law case. If the employee that was injured had not been a whole employee, no one would argue that whole shouldn't be in as a general contractor. Right? Okay. The contract says right at the beginning, this is a contract executed by Whole and Brand Safeway, whereas the parties agree that the subcontractor, that's Brand Safeway, shall, in the place of the contractor, perform the part of the general contract.
To build the scaffold.
For the scaffold.
Right, but we're talking about delegation for agency purposes. You need to delegate supervision and control over the area or the work.
And if they are to become, they are to take the place of the contractor with regard to the scaffold, then they would be in the same position as Whole would have been otherwise.
Wasn't it you who was arguing below that the work is being done on the boats itself and not the scaffold?
Likely.
So that undermines this argument here that you have.
No.
But in any event, so you want plaintiff and you are going hard. Is there an insurance coverage issue here from the from Maid of the Mist and New York Power Authority?
Not that I'm aware of.
So if plaintiff wins against the sub, he wins against your client and the Power Authority, right? I mean, I just don't get, not this, neither here or there, but I don't get all this hyper focus on the sub. We don't usually see that unless there's a problem with collecting from one of the higher parties.
There is no problem. And there's insurance for Maid of the Mist, there's insurance for Whole, there's insurance for Niagara Parks. That's not the issue. The issue here is a very clear one. If we want to talk about 240, let's go to 241 sub 6 for a minute. Okay. And the argument of which of the two regulations applies, because if you look at this as a fork in the road, if we go one direction and we talk about this as a metal scaffold, right, as opposed to a vertical passageway, if this is a metal scaffold, there's no question that he was provided with an appropriate means of getting to the top section of the scaffold.
Correct. Because you could use ladders alone under 23.5.3, right?
Exactly.
But you need to use stairs if it's 23.1.7. So what if it's a wooden scaffold? You mean to say you get more protection on a wooden scaffold than a metal scaffold?
What if you're climbing a metal scaffold and you're climbing up and you're stopping at let's remember why the scaffold is there. This boat is delivered in sections. And this boat, these two pieces, and then three pieces, and then four pieces, they all need to be welded together. You don't weld just the top, you don't weld just the inside, you weld the outside. These scaffolds are used to weld that seam on the outside. So there are people utilizing that scaffold from the first level. There are people utilizing that scaffold from the second level. There are people utilizing that scaffold from the third level. And let's not forget that the scaffold is the entire top of the boat as well. The picture, if you look at the picture, it was exhibit number 22 to depositions. It's at page number 29 in Ethan's brief. It shows the top. This is a picture that he took. It shows the top of the boats. And you can see that when you come up the scaffolds go all the way across. So it's not like he's climbing up a 3-section Baker scaffold and getting off onto the boat. He's getting to the top and then he's walking on an extension of that exact scaffold.
Okay.
It's clear right in there. So you asked the question, do you get more protection if you have a wood scaffold than a metal scaffold? First of all, I don't know people that are still using wood scaffolds,
Probably
but the point is well taken, and it comes to the same exact argument. Do you get more protection if you're stepping off onto an extension of the scaffold at the top than if you're the guy sitting on the second level welding? If it's safe for the guy to go to the second level and weld, why isn't it safe for the guy to go to the third level and weld on the top of the boat? Or to go across to the third level and walk on the scaffold and go into the boat to weld from the inside?
Right. So your argument is we should look only at 23.5.3F and ignore 23.1.7F, and we get that, and that's brief.
What 1.7F is general to all things.
Gotcha.
This is very specific to metal scaffolds. This is a metal scaffold. They look at the picture on page 29. The whole top is a scaffold.
Okay.
Okay.
So
I think that the court has heard a lot of argument on it. Unless you have more questions about which of the two should be applied.
yeah, no, you guys I have to say I commend all three lawyers for the briefs. Very, very helpful, high level of work. So we've got that issue. Briefly, if you could touch on 240 sub 1 before you sit down.
Okay. Well, then we move on to the negligence in 200
Okay.
on behalf of Brand Safeway.
Yeah.
And this is where we come to the contract. And this is that fork in the road that I talk about. Because I'm agreeing with them that I believe that this is a metal scaffold and not a vertical passageway. And if the court finds that this is a metal scaffold and not a vertical passageway, I'm not suggesting that they are necessarily negligent, right? Because if that is the case, and this is a safe method to go up there, then there is no 240 sub 1. Okay, let's talk about what their obligation was. The obligation of Brand Safeway. Okay, so they're taking the place with respect to the scaffold, not with respect to everything else, just in respect to with the scaffold, they are taking the place of the contractor. They are becoming the contractor. Insofar as work having to do with the scaffold is concerned. The subcontractor, Brand Safeway, had acknowledged that it had investigated the nature, locality, and site of the work and the conditions and difficulties under which the work is being performed. And it enters into the subcontract based on its own examination, investigation, and evaluation of all such matters. Okay? They didn't come into this blind. They came into this understanding exactly what was happening here, that the scaffolds would need to be moved, that the scaffolds needed to be available to people to weld on the outside and to get to the portion of the scaffold that they built that went across the top, all depicted in that photograph. Okay? They then had the obligation, and this is when we get to section 9, they had the obligation for the subcontractor shall its sole cost and expense strictly observe and comply with all applicable safety laws. I don't think that there can possibly
At their
be.
own expense.
Pardon?
At their own expense. There's another that goes on, right?
Yeah.
But so again,
But they had an obligation to let's not forget what Maid of the Mist is. The Maid of the Mist is in the business of entertainment. They're in the business of taking people to see Niagara Falls. They're not in the business of scaffolds. And they're not really in the business of building boats. They hired marine engineers from the Coast Guard to come in and oversee that. They're in the business of entertainment.
but you see, would you agree on a basic fairness level? Brand Safeway's argument is we tried to sell them a scaffold with stairs. It was $1,500 a month too much. Holt said, no, we're good with just a scaffold. And now under this contract, not only are they liable, but they were supposed to, at their own expense, the subcontractor put in stairs. Even though what the contractor paid for and ordered did not have stairs.
They were supposed
That doesn't
to.
seem how it works in the marketplace.
They were supposed to know if stairs were necessary.
And then put them in it, but. Okay.
They didn't even say, if they came to us, Your Honor, if they came to us and said, hey, I know you guys are in the business of taking people on boat rides, but let me tell you something. I am the expert in this area, right? I am the expert, which is what they say.
Whole had a safety manager expert too walking around and.
Well, first of all, Hole's not a party.
Right,
So
no, I understand.
let's not drag Hole into this. Let's talk about Maid of the Mist.
Yeah.
Okay? But subcontract represents it as fully experienced and properly qualified as an expert. Okay? That's Brand Safeway.
So if the expertise is, if their expert advice is ignored, they're supposed to do it anyways and not get paid.
They didn't tell us that this was required. This whole concept that they came to us and said, oh, would you please put stairs on? And we said, no, we can't spend $1,500 when we're talking about I think it was an $80 million boat or something. I mean, come on.
Right.
That's ridiculous. It was a
Time.
pick list.
Last question on this because we're moving on time, but wouldn't the requirement for stairs vary over the course of the construction project? Based on the nature of the work, it changes and maybe they weren't required at the beginning, but it could be required as we go, right?
And they were there 4 days before, and they could have, if they thought it was required, if they knew that this, let's not skip over the fact that they still contend, and I agree with them, that this is not a vertical passageway, but rather a metal scaffold, and thus stairs are not required. And if the stairs are not required, we have a perfect sole proximate cause against the plaintiff, and I respectfully disagree with you, Your Honor, that he hits all 5 points, right? An appropriate safety device provided for his use that he absolutely knew he was supposed to be using. He admitted, I know I'm not supposed to climb with holding something. I know 3 points of contact is wrong. That he misused it by carrying the thing up. That was for no good reason. He had other options to take it up. He had the rope right there. You talk about the bucket. You'll recall the very next question I asked was, couldn't you just tie a rope around it and bring it up? Yeah, but I don't, didn't want to, whatever. I
He
mean,
didn't think that was safe, but
whatever. He thought it was safe to climb holding that thing when he decided that he was going to carry that thing when he knew. And remember his testimony. His testimony was very specific that this was the first time he had ever done it. So this entire argument that that's how they got stuff up the whole time is invalid, because he testified that was the first time he'd ever done such a thing.
Right.
Okay.
Thank you for your time and your advocacy, and we understand your points. Thank you.
Thank you, Judge.
Case number 312 is Manor versus Nancy. I believe we are, Mr. Goldblatt's ready to go, so please commence.
Good afternoon, Your Honors. May it please the court, Nicholas Rietzko on behalf of the defendants appellants. Your Honors, this matter was before this court a few years ago on basically similar issues. Justice Lindley, Justice Montour, and Justice Greenwood, you were on that panel when this matter was before the court. I actually went back and watched that oral argument, and I'm going to start with kind of addressing some of the concerns that the court had a few years ago. And one of the biggest concerns was potential prejudice that the plaintiff was going to face without having access to this raw data. And I think it's the prejudice that my clients, the defendants here, is going to face with this lower court's decision. Right now, we're not going to have an expert at trial.
Well, listen, last time we were here, you said, and I'm not questioning your integrity, but the argument was being made, if we reverse, your client is never going to find a neurological expert who's going to willing to test this plaintiff. And we sent it back and we said, no, you guys came up with one. Okay, one of these experts, we kind of called the bluff, and then you found an expert. So now we have the neurological test that your client claimed was never going to be obtained. Now the question is, should the raw data and the test data and so forth be turned over? Would you agree, and you make a lot of good arguments, but would you agree with this? If the expert testifies at trial that the plaintiff is feigning neurological damage, cognitive difficulties. In other words, she claims that she has difficulties cognitively, but she's faking it. Or the plaintiff's lawyer, to cross-examine that expert effectively, needs to have the raw data and needs to know what the test questions are and how it was evaluated, right? Would you disagree with that?
I would disagree. And if I could just respond to the first point Your Honor just made. When we were here 2 years ago, what we were arguing is we were never going to find a neurological expert that would release the data directly to plaintiff's counsel. And we're still in that position. Dr. Santa Maria will not agree to release the data directly to plaintiff's counsel. He will agree to release it to plaintiff's treating physician, with the understanding which he did.
With the understanding that the plaintiff's treating physician will then turn it over to plaintiff's lawyer, right? Which is unethical according to your position.
No, we don't know if he was going to do that, and I don't know if he has, and I don't think he will. But to answer your question, plaintiff can talk to Dr. Griffiths and prepare for cross-examination that way. The same way we're going to have to talk with Dr. Santa Maria, because I can tell you, Your Honor, Dr. Santa Maria is not releasing the raw data to us. So we're going to be in the same boat as plaintiff's counsel is. Dr. Santa Maria is not going to release the raw data to us. We don't have Dr. Griffiths.
Are there any neurologists who are releasing this? Because we've seen this issue a number of times, and it seems like they're being released right and left.
Not the three that we spoke to. I think in the past,
in your little universe, yeah, but I'm talking about in the universe of all neurological, we see this all the time. The raw data is being released.
Well, I think
With
things have-
confidentiality.
I'm
orders.
sorry, Your Honor.
With confidentiality orders for the plaintiff's lawyer.
Well, things have changed over the years, and to a point that Justice Montour brought up at the last oral argument, these confidentiality and stipulations aren't working. And in a case that plaintiff's counsel relies on is the Collins case that he was a part of. And that's cited at the record, page 102, even admitted to retaining documents in a case from a prior case that he got records from a prior expert that he still had. So these confidentiality and stipulations aren't working. And that's the concern that these neuropsychological experts are having. They're getting in the hands of people that they shouldn't have, that they don't have the proper licensure.
And what's
they're
the danger? The danger is it was explained previously, is that this information, raw data, is going to be used by future patients to cheat on the test.
It's that, and that it's going to get into the hands of people that aren't bound by the same code of ethics as these neuropsychs. So it's twofold. It's that and the fact that it's going to get into the hands of people that.
Okay, so let's assume that's legitimate. Isn't there a legitimate concern? On the other hand, we need effective cross-examination of the neurological expert by a plaintiff. How can we do that if they don't know, if they don't have the raw data?
He can call Dr. Griffiths on the phone, take the step, and he can ask those questions with him. He's just not going to get the material in his hands, but that's the same thing that we're going to have with
Okay,
Dr.
so he can get
Santamaria.
verbally everything, he just can't get it in writing.
Correct. He's not going to get the materials in his hands, but that's the same thing that we're going to get with Santa Maria. So we're asking this court to vacate that lower court.
So can the lawyer just take notes like, slow down, let me just get this down?
Well, sure, he can take notes, and that's, but that's.
So what's the big difference there between getting the actual, writing them down himself, transcribing like a court reporter, or getting the actual?
I don't think it's going to be verbatim, question by question, and the raw data and the stimuli and the responses that is that raw data. I understand your Honor's point, but it's the actual materials. And Dr. Griffiths, the letter that he sent to Dr. Santa Maria, the same testing materials that plaintiff's counsel wants, Dr. Griffith didn't even disclose those to Dr. Santa Maria because he points out that those are copyrighted and I'm not turning those over. So the same testing
He
materials.
doesn't have to turn them over. It doesn't mean he can stroll in the court and start giving opinions on them.
I'm sorry, Your Honor?
He doesn't have to turn them over. But the question is, can he stroll in the court and start opining based on his results? And he doesn't want to turn over his raw data. That's really what it is. But look, we've been through this last time. He makes some good arguments. He makes some even better arguments now. So we're going to have to take a really close look at it. Is there any updated case law that you have now for us before that you didn't have last time around?
No, Your Honor, there is no updated case law. And then really the only case from this department would be that one from 1998. I would just distinguish that because there's the update with the Code of Conduct from 2010 and the amendments in 2016. And the record that you have here is you have 3 neuropsychological affidavits that we submitted. And I would say that plaintiff's counsel didn't submit any affidavits to, go against what those 3 neuropsychs were saying as to the concerns that they were raising.
Right.
But I don't want to underscore the point, if you reverse what the lower court did, we would be on equal footing with the plaintiff here. We don't have an unfair advantage because we don't have Santa Maria's raw data and we're never going to get it. And we don't have Dr. Griffith's raw data and we're never going to get it. So we don't have an unfair advantage over plaintiff's counsel. But if you leave this order in place, we are going to be profoundly prejudiced because we will not be able to submit Dr. Santa Maria at trial. We're going to be without an expert.
Do you honestly think, and I've read those, that updated ethical, those rules. Do you honestly think your client's going to be subject to ethical charges if he turns over the raw data? With the understanding that those rules expressly contemplate turning it over with confidentiality orders.
Well, I mean, that's what he's telling. I don't know if he's going to be brought up on ethical charges, but he's telling us that he's not going to turn that over. So the lower court's order is if he doesn't turn it over.
Expert, maybe, I don't know.
But I just want to this is none of our client's own doing. This is Dr. Santa Maria. I can assure the court, we want our client to have an expert at trial. So this is all through none of our client's own doing. And the impact that I think, whatever the court rules is going to have, an effect on civil defendants beyond this case.
So you cited last time the 3 neurological Santa Maria. Have you gone beyond that? Because there are neurologists who are giving up their raw data right and left in courts in the state of New York. Did you ever check with one of them?
I mean, we went with 3 from west of Albany to here. We didn't go beyond that. We went with 3. I mean, it wasn't just one.
Right,
We went
I
with
got you.
Langfit, Dr. McCaffrey, and Dr. Santa Maria,
Okay.
west of Albany to here, Joe. So I would submit We would ask that the court reverse the lower court and grant our order of protection.
Thank you, counsel.
Thank you, Your Honor.
Mr. Goldblatt.
Thank you, Judge. Good morning, good afternoon, Your Honors. It's morning where I am, but I want to narrow the issue in this case. The initial motion and the arguments made by the appellant, they acknowledge my need for this material in order to cross-examine their expert. And on their motion to renew, they then relied upon this supposedly new position statement, which was not new. It's a reprint from something 2 years earlier that says, I'm not allowed to get this material at all because I'm a plaintiff's attorney, and plaintiff's attorney in general are unscrupulous and cannot be expected to be bound or follow a confidentiality order. And we will teach all of our clients to cheat these tests. First of all, my client has taken the test, so she can't cheat. Counsel made a statement that I admitted that I didn't follow a confidentiality order and I retained materials. That is a blatant misrepresentation. In fact, in the record is a letter sent to Dr. McCaffrey, who the defendants relied upon, returning the materials that Dr. McCaffrey gave to me. Dr. McCaffrey routinely exchanges these materials with my office and other lawyers that I've worked with pursuant to the same confidentiality order. Now, here's the misnomer. The appellants keep arguing, I can get the materials from Dr. Griffith. What appellants keep not telling the court, they didn't tell the lower court, they didn't put it in their brief, and they didn't say it now, is that Dr. Santa Maria gave this raw data to Dr. Griffith was an express proviso that it not be shown or discussed with Goldblatt.
Right, but aside from that, if Santa Maria is right, it's unethical for Santa Maria to give it to you. Then it's also unethical for the treating neurologist to give it to you, right?
It is unethical it's a neuropsychologist. It's if you follow that logic, yes. But more importantly, it's unethical for one neuropsychologist, Dr. Griffith, to exchange with anybody the raw data from another neuropsychologist.
How about this issue, because we're running short on time, where he says there's an unfair advantage is that if Santa Maria turns it over, Bear's not going to turn it over, and it should be level.
I'm sorry, can you repeat that?
I just heard him say that if Santa Maria has to turn over the raw data to you and the test data, then it's not going to be an even playing field because he's not going to get the same from Barrett.
From Barrett?
Maybe I misunderstood. I'm sorry, Griffith, yeah.
So what counsel said, Your Honor, is that they're not going to get the raw data from Santa Maria, so why should I? And if I don't get it, then we're on an even playing field. They don't need the raw data. The raw data is used to cross-examine, not for direct examination. There is nothing unethical. In fact, the APA that they rely upon specifically says you can give that data to whomever the person you test signs an authorization for. You can also give it pursuant to a court order. And this is what all of the case law that I've cited from this department, from all over the state, has said. They have rejected every single argument. The same arguments made here, and said, we're giving it to the plaintiff's lawyer directly under the guise of a confidentiality order. It's the same confidentiality order that I have prepared for 15 or 20 years, that almost every case I cited to you was from my office or some other office that I helped write. I want to cite to you, Judge, the failure to get this material, it violates the tenet of our legal system, the right to confront an adversarial witness. And this is why these doctors do it. They don't want to be cross-examined. and they score the test wrong, they administer the test wrong. I'm going to read from you a quote from a case from Judge Murphy. I won't ask the court to have to cross-examine an expert without having all the information available to them. The expert reviewed, and that was done as part of their exam. So I'm going to deny the motion for a protective order to the extent that it seeks to limit the disclosure of the raw data and the test booklets to the attorney for the plaintiff. That was a case in Morgan. I also cited
We
another
saw
case.
that in your brief. We did see that in your brief. Anything you want to say in closing here?
Judge, what I want to say in closing is that Dr. Santa Maria, first of all, you asked this question before. I can represent to you neuropsychologists are performing neuropsychological testing all over this country and releasing the raw data pursuant to the exact terms of confidentiality that the lower court here, Judge Denton, ordered the court to do it. There are 3 neuropsychologists is not representative of the establishment, and Dr. McCaffrey, I'm representing to you, has routinely turned this material over with a court order. What's going to happen in this case, if this court affirms this decision, is Dr. Santa Maria is going to exchange the data. And if he doesn't, he's never going to be hired again for a forensic exam. And he's not going to give up this income. And that's the same thing that Dr. McCaffrey and all of these cases that I've cited to this court, the same arguments were made by the neuropsychologist, and every single time, miraculously, they turned over the data because they make a lot of money doing this forensic work, and he's not going to give it up. The reality is he may think he has these ethics in a clinical practice. You want to play in the field of forensics, you got to abide by the law. You got to abide by the rules that the court set. And Judge Denton put it nicely, she's not going to be held hostage to a doctor by a doctor who's not going to follow the law. The third department in a case I cited on another issue neuropsychologists use about trying to keep third-party observers out. Go find a neuropsychologist who will follow the law. There are lots of them. With respect to preclusion, the defendants knew I was going to raise this issue again. This court specifically gave us the leeway to do it. I put them on notice before the exam I was going to raise it. They voluntarily chose Dr. Santa Maria. He voluntarily and willingly took the money and did it. And lo and behold, she's malingering. So the fear, this fear-mongering that it's going to be the destruction of the field of neuropsychology, doctors all over the country are still finding plaintiffs malingering despite the fact that raw data is being given out. There is no credibility to their position. They haven't cited one case, not one case in New York where this argument was accepted by a court. And this court shouldn't start disregarding all the case law, including from the fourth department. Unless anyone has any further questions, I'll rest on my brief, Judge.
Thank you, Mr. Gilbert. Last case on the docket is 317 Kaplan versus Tully Central School District. Thank you for your patience for the long morning.
Afternoon, Your Honors. I know we're in the home stretch here. I'll be brief and succinct. May it please the court, I'm Daniel Pouch from Von Schoeneck and King on behalf of the defendant appellant, Tully Central School District. This case, Your Honors, is very simple, both in terms of the salient facts as well as the law. The plaintiff here resigned from their position with the district after being told that they were not going to be recommended for permanent employment after the 12-month probationary period. Despite never telling anybody in the district administration that they were either transgender and or disabled, after resigning, the plaintiff then filed an EEOC complaint alleging discrimination based on purported gender identity as well as disability discrimination based on ADHD and OCD. On summary judgment, the trial court dismissed the plaintiff's disability discrimination claim, so that's no longer part of the case. The sole issue remaining is whether or not the trial court erred in finding that an issue of fact exists with respect to the gender identity discrimination. As the court is aware, in order to survive summary judgment on that type of claim, the plaintiff has to present some evidence of a causal connection or nexus between the gender identity and the adverse action that was taken here by the district. There's no connection here showing any sort of inference of discrimination at all. There is no circumstances giving rise to an inference of discrimination. Because of that, the plaintiff can't make out a prima facie case of discrimination. The most compelling fact in support of that argument is that the decision maker here, the superintendent of the school district, Mr. Hughes, he had no idea, and this is undisputed. He had no knowledge,
Well,
no idea.
I don't know if it's undisputed. I don't think there's any evidence to the contrary, but there would be hard for the plaintiff to get evidence of the contrary, seeing that that's knowledge in the exclusive brain of Mr. Hughes. In other words, Mr. Hughes says, I didn't know. How is a plaintiff supposed to challenge that?
Well, the plaintiff certainly didn't tell Mr. Hughes.
Right.
That's
I agree.
undisputed.
No dispute, but his supervisor, Mr. Corbin, I think his name was, allegedly knew, and then Corbin made a recommendation to Hughes. So, but I agree. I mean, Hughes makes that statement in his affidavit. I had no idea. Are we just supposed to accept that as a matter of law? When plaintiff, how is he going to know what's in Hughes' mindset?
So it's really interesting on this point, Your Honor, and I was going to bring it up at some point, but if you look at the trial court's decision, the trial court, it's the same situation with respect to the disability claim, right? With the disability claim, Hughes says, I had no idea. Corbin never told me. And the court accepts that. Yet with the gender identity discrimination claim, Hughes says, I had no idea. Corbin never told me. All of a sudden, that's an issue of fact. That's completely inconsistent.
Corbin did make a recommendation to Hughes, right? And you would agree there's an issue of fact whether Corbin knew about the transgender identity, right? There's an issue of fact on that, at least.
It's not, well, there's, at least with that, Your Honor, the plaintiff claims that the plaintiff told Mr. Corbin, I am transgender.
And there's some circumstantial evidence suggesting that it might be true. In other words, change in behavior, telling the other woman not to walk with them based on perceptions and so forth. But you're right. Plaintiff, Hughes says, I had no idea. And plaintiff really is not in a position to challenge that. If a jury believes Hughes, then I think you win. The question is, should it be 30-11 or should it go to trial on that particular issue? I know you got a lot of other issues. There's a lot of non-pretextual reasons here, a lot of very questionable behavior by this petitioner with the cousin with the Bob Marley postcard. I mean, it's just, we could be here for an hour with all of the questionable decisions he made with his respect to his behavior. But do you want to address this whole pretext plus issue? And there seems to be some confusion in the case law of what the burden of the plaintiff is if we get to that last stage.
Yeah, and Your Honor, I mean, respectfully, I'm not, 2 points on that. I'm not really sure there is much confusion. I mean, I think the lower court correctly in the pretext plus based on the Jewish Guild case, there's, ample case law on that. But what I will say, Your Honor, is, not that it's irrelevant because it certainly is relevant, but under the pretext or the pretext plus analysis, plaintiff fails either way. Okay, because one, with respect to just falsity itself, okay, are the district's reasons for termination, are those false? That's analysis one, okay? Clearly, the plaintiff acknowledges that they engaged in this behavior. They showed up to an elementary school with a cousin costume on, covering their face, playing a practical joke in an era of school shootings, okay? They're riding around campus on a scooter. They're dancing in the middle of Route 80 with a pink wig on. They're sending, imagery with marijuana related to posing. I mean, whether plaintiff agrees that is indicative of poor judgment is irrelevant. It doesn't show falsity because the plaintiff agrees that those things happened. So, you can't say that the district's reasons were false if it's relying on events that no one's
Do they have to
disputing.
show, are you familiar with the Morse case from this court? Morris versus Wyoming County Community Hospital. It's a 2003 case.
Yeah, I read that case,
Yeah,
Judge.
because it said if there is an issue of fact considering either the falsity of the employee's explanation for the challenge action or the employee's discriminatory motive, it was either or.
Yeah.
But the Court of Appeals forced him to say you got to have both. The place got to get both. You wanna-
Yeah, and that's the Jewish Guild case says both, right? The
Yeah.
Court of Appeals case. But Judge, to your point, so let's put the falsity aside. Okay, let's now focus on, the real reason for the district's action. There's still no causal link at all. There's no evidence at all connecting the gender identity to the adverse employment action, right? Plaintiff points out, correctly in the brief that there was no written counseling. Okay, there was no written counseling, but each one of those 5, cases of extremely poor judgment, the plaintiff was counseled on that. They were told, don't do that. Why are you doing that? Okay. Next, this argument about, there's no question, no one's disputing the plaintiff we talked about a second different role during a probationary period. That's the entire reason of having a probationary period, is so you can get rid of an employee as long as it's not for a protected classification or status.
Counsel, let me ask you a question. In the standard that Justice Lindley just referred to, whether the reason was false or that the discrimination was the real reason, is there anything in the record that the plaintiff demonstrated that either one of those factors exists?
Nothing, Your Honor. There's no causal connection at all.
So even if Mr. Corbin, that's one of the questions that Justice Lindley brought up, that the superintendent may have known that the bus driver was transgender through his conversation, but does that matter if this part of the record isn't satisfied for our analysis?
It doesn't matter, Judge, because if it did matter, then every decision maker who was aware of any protected classification under any circumstances could be inferred that they were discriminating if there's an adverse action taken. Just because Mr. Corbin, if we assume for argument's sake, Judge, that Mr. Corbin knew that plaintiff was transgender, and even if we were to assume that Mr. Corbin had some influence on Mr. Hughes's decision to not appoint or recommend plaintiff for permanent employment, that doesn't matter because there's no evidence at all that Mr. Corbin had any idea that plaintiff was purportedly transgender. To answer your question, Judge, if you look through this record, there's no evidence. Your Honor's next, this argument about telling plaintiff not to walk with, a payroll clerk. Again, there's a gender neutral explanation for everything that the district did, right? At that point, there was an employee in the bus garage that was causing problems over in the business administration building where this payroll clerk worked. So the Mr. Corbin was not concerned about who plaintiff walked with. Mr. Corbin didn't care who the plaintiff walked with. Mr. Corbin was telling his employee, the payroll clerk, look, I'd rather you not be walking around with the bus garage people because there's all this going on. That has nothing to do with purported gender identity. And in closing, Your Honors, unless there's specific questions, to Judge Greenwood's point, if we search this record high and low, we're not going to find any causal connection, any nexus between the plaintiff's purported gender identity and the adverse action that was taken. Because of that complete lack of connection or nexus, summary judgment has to be granted here, because if it doesn't, and it's not granted, then, there's no such thing as summary judgment in Title VII cases.
Thank you.
Thank you.
Mr. Jerome.
Your Honors, may it please the court, Nathan Gerald on behalf of plaintiff Ika Clapton in this matter. This is a case about issues of fact. On April 12, 2024, the Onondaga County Supreme Court ruled that there were fundamental issues of fact in this case that precluded summary judgment. On appeal, defendant has not provided any justifiable reasons for this court to overturn that decision. First, when we look at the lower court correctly found that plaintiff established the prima facie burden of this case. This is a de minimis burden.
Right, can we go right to the third burden with regard to pretext? That seems to be would you agree that seems to be where this case is going to be decided?
Yes, I do. We can certainly start there, Your Honor. With respect to, I think, let's start with if you don't mind, let's start with the knowledge piece, because I think that applies at multiple stages here. One of the main points that the defendant has focused on is that he alleges that it's undisputed that somehow Hughes didn't know. And as this panel has already pointed out, plaintiff is not required to produce direct evidence of knowledge. I cite the Gamble case in our responsive papers. In that case, it is recognized that a plaintiff in a Title VII hearing is not required to produce direct evidence of knowledge, and that knowledge can be inferred from the totality of evidence in the case. And what do we have here to infer that Hughes knew? What we have is Bradley Corbin testifying that if an employee came out to him as being trans, probably his first stop is going to be Robert Hughes's office to talk about it. And what we know is that from deposition testimony, Ika Clapton testified to telling Bradley Corbin that they identify as being transgender in June of 2015. This presents a clear issue of fact and a basis by which a jury could reasonably infer that Hughes knew. The defendant tries to discount this by chalking this up to a hypothetical, but the case law that the defendant relies upon for this position is factually in opposite to the present case. They rely upon three cases that are analyzed the basis of expert opinion. In the Bergstrom and Kelly cases, for example, the expert opinions did not rely upon any facts in the record. In this case, the question of Bradley Corbin was based upon Ika Clapton's testimony, stating that they told their supervisors that they identify as transgender. So this is clearly based upon record evidence. Beyond that, in their reply, they also discuss these two other cases, Murphy and Trinidad. The plaintiffs in those cases testified that they were other employees that would corroborate their claims of discrimination by the employer, but they never offered any evidence to support that allegation. There was no affidavit from these so-called employees. There was no testimony from these so-called employees on the basis. So again, that's not what we're dealing with here. We're dealing with Ika Clapton's direct supervisor, someone that was directly involved with the discriminatory treatment. And someone that said that, yes, if an employee came out to me as trans, I'm going to tell the board, I'm going to tell Robert Hughes. This creates a clear mechanism by which a jury can infer Hughes knew before the decision was made.
Did Mr. Hughes ask Corbin for his opinion on the plaintiff's permanent status?
He did, Your Honor.
And then did he also ask Corbin to keep an eye on him?
There were multiple discussions about Ika Clapton. They've alleged that they did talk about Ika Clapton during the approximate 9 months prior to this decision being made by the district. And to that point about these conversations, the defendant has raised, that there were verbal conversations, and how can the plaintiff demonstrate falsity when they've admitted certain aspects of these accounts, right? But that's not the fundamental falsity at issue. The fundamental falsity at issue is whether the district itself genuinely believed this conduct merited discipline or termination. And there's a fundamental issue of fact about that point, because they admit Clapton received quarterly performance evaluations. Yet, despite 5 instances of questionable conduct that they've alleged, right? The wig, the scooter, the shelf, the cousin it, and the postcard, 5 over the course of 9 months. It never materialized in any of Clapton's performance evaluations. That presents a serious credibility issue.
Does the plaintiff have to show that other people did similar things and were hired or not fired?
I'm sorry, say that again, Your Honor.
Does the plaintiff have to show for pretext that other people did similar things, not like cousin Ed and who's going to do that, but similar acts of misconduct that were eventually taken from probationary status to permanent status were not fired?
Not necessarily, Your Honor, because in this case, what we can show is that the fact that none of this conduct came up in the performance evaluation, that creates an issue of fact as to whether they genuinely believe this merited termination. Beyond that, we have the other factors in the pretext and in the prima facie case that indicate that there was a discriminatory motive here. So the question is whether or not they were treated. So in a sense, yes, were they treated differently because they were transgender? That is part of it. And I think one mechanism would be is to point out, well, look at how they treated other employees that were probationary as well. So that would be a mechanism. But in this case, the plaintiff is relying upon the marked change of relationship that occurred immediately after the disclosure happened and all the questionable circumstances regarding the secondary probationary appointment. So we've talked about the fundamental falsity of the disconnect between the performance evaluations and these verbal counselings and the fact that
How many performance evaluations were there?
So they admitted that Clapham received quarterly evaluations and that the last one was on December 18th, 2015, mere weeks before the January 5th decision not to offer a tenured position. So when we're looking at that, right, you would expect, so that was after all this alleged conduct happened. If there was a serious concern about their lack of judgment and professionalism, at a minimum, that would be the place to say, we have serious concerns about your performance. Yet it's
Was the counseling that your opponent indicated your client received after these incidents, was that at all in these performance reports?
What's in the record, Your Honor, is that Clapham received quarterly evaluations and that Clapham never received a negative evaluation.
But your opponent indicated that after these incidents, your client received some sort of counseling.
That's correct, Your Honor.
Was any of that in his file or in his quarterly exams, anything along those lines?
So Mr. Hughes admitted in his deposition testimony that he and Mr. Corbin never discussed documenting any of these concerns. So on that basis, I would say the defendant has not produced any records to show that these concerns were documented in any form or fashion. So on that basis, I would say no, Your Honor.
Anything further?
Yes, Your Honor. I want to just briefly clarify some of the irregularities and inconsistencies of the secondary probationary appointment, because these two speak to pretext. And first is that if there was a genuine interest in having Ika Clapham apply for a new probationary appointment, you'd expect that Mr. Hughes and Mr. Corbin would be aligned in this purpose. Yet they have fundamental difference of opinion about what happened in this January 5th meeting. Mr. Hughes says they generally wanted Ika Clapham to apply for this bus garage supervisor position. Yet Mr. Corbin says it wasn't like that. It was more something along the lines of, we can't deny you the opportunity to apply. That presents an issue of credibility about whether there was a genuine interest in having Ika Clapham come back. Also, again, there is a fundamental disconnect between the fact that Clapham didn't qualify for the position as written.
Ika didn't qualify for that position. There were requirements that they didn't have.
Correct, Your Honor. And beyond that, they did not disclose that they could modify this position or modify the job description. Again, if this were a genuine interest, that would be a material thing to share with the plaintiff, but they did not. And that is further proof of pretext that there was no genuine offer. And so beyond that, Your Honor, we'll rely upon the papers pending any further questions in the court.
Thank you very much.
Thank you, Your Honor.